to be mentioned item number 1.
May it please, Millards. Millards, I beg to appear virtually, Millards, in this matter, Millards.
Yes, yes.
I believe, Millards, this matter is listed pursuant to the order of the Honorable Supreme Court, where that an order has been passed in that case, Millards. Millards, to assist your lordships, I have prepared a very short note, which I may kindly hand over to your lordships. If my associate is there in...
Can we take a different view than what has been taken by the Supreme Court?
No, Millards. Your lordships can take, Millards, as your lordship pleases.
So
But
this is what
that is not the view. It is not the view. My humble submission, it is not the view of the Honorable Supreme Court. That Millards, in my humble submission, Millards. So therefore, Millards, if your lordship will kindly permit me, Millards, in 2 minutes I'll...
No. See, the Supreme Court has affirmed the view taken by Meghalaya High Court.
Yes, Millards. And
All
Meghalaya
right.
High Court,
So-
Millards, speaks the same language as your lordship.
No.
Yes,
Meghalaya-
Millards. Yes, Millards. Yes, Millards. Your lordship will have that note. I have given that note, Millards. Millards will see. Firstly, Millards, your lordship will kindly come to page Millards of...
Mr. Acharya, we were of the definite view that the extension cannot be granted by a high court which does not have the original jurisdiction.
Millards.
All right. So only such high courts which have the original jurisdiction can grant. All right. Civil court of, what is the expression?
Of original jurisdiction.
Principal civil court.
Principal civil court of original jurisdiction
jurisdiction.
has the competence to extend.
No,
That-
Millards. This is the earlier view. The division bench of your lordships.
That's the part.
Plus the division bench of your lordships have rather held that it is the High Court which has the power.
Yes.
Yes, Millards.
So that view is incorrect in view of the view which has been taken by Supreme Court.
No, Millards. Millards, Meghalaya High Court speaks the same language as the division bench of your lordships. And Meghalaya High Court, against Meghalaya High Court, the SLP is dismissed. And therefore, Millards, if your lordship will kindly have that note for a minute, it will make things absolutely clear, Millards. Millards will turn to page 11 of that note.
Just
The
a
judgment
minute.
of-
Just a minute. Just a minute. And we will not just let us see the Supreme Court's order first.
Milord, may I just share the Chief Engineer PWD order, Milord, which is...
I have, Mr. Das, I have given that in the compilation.
Could you share your note, please? I'd be very grateful.
Very well. I'll do that. Millards will see the order, which is at page 13, is the Supreme Court order, Millards.
Yes, it's so clear. So,
Millards, may I just...
first paragraph of the order, the power under subsection 4 of section 29A of the Arbitration Act rests in the High Court as defined under section 2(1)(e) of the Arbitration Act. 1. 2. It is the principal civil court of original jurisdiction in a district which includes a High Court, provided High Court has ordinary civil jurisdiction.
Yes.
So the Odisha High Court does not have that power, that jurisdiction.
May I
It's so
demonstrate?
clear.
May I read further, Millards? May I read further?
Yes, yes.
In this case, the High Court does not have the ordinary original civil jurisdiction. The power under subsection 6 of 29A is only a consequential power vesting in the court which is empowered to extend the time. If the court finds that the cause of delay is one or all of the arbitrators while extending the time, the court has power to replace and substitute the arbitrators. The said power has to be exercised by the court which is empowered to extend the time as provided under section 29A(4). Hence, Millards, there is no merit in the SLP. The same is accordingly dismissed. So, Millards, the Meghalaya High Court judgment is upheld.
Meghalaya High Court judgment is upheld, but there is a reason. Both the paragraphs will have to be read together.
Yes, Millards. Since, Millards, it's a dismissal of SLP, Millards, I'll bow down to whatever your lordship's view is.
See, so the sentence is so clear. In this case, the High Court does not have the ordinary original civil jurisdiction. So in this case, the Odisha High Court does not have the original civil jurisdiction. The power under subsection 6 of 29A is only a consequential power vesting in the court which is empowered to extend the time. If the court finds that the cause of delay, the said power has to be exercised by the court which is empowered to extend the time as provided in subsection 4 of section 29A.
That's
so clear.
I'll bow down to whatever Lordship's view is. Before that, your Lordship will kindly have page 11 of that note, which is the Meghalaya High Court judgment. That is, to understand the context in which the order has been passed.
See, because a judgment has been affirmed by the Supreme Court, we are not required to follow that decision of the High Court. What we are required to follow is what has been held by the Supreme Court in its order.
Yes,
but Supreme Court's order is very clear on that point.
No ambiguity. My lords will kindly have page 11 of that note, my lords, kindly for a moment.
All right.
It will make things clear, my lords. Just an endeavor, my lords.
Play page 11 again. You must be referring to Meghalaya.
Yes, my lords. If your lordship will kindly have it for a moment, my lords.
Yes.
Para 16.
Yes.
Thus, it is seen that the term court used in 29A4 as the definitive clause has provided in section 2.1 is to be interpreted by making use of the expression unless the context otherwise requires. The phrase unless the context otherwise requires in the view of this court is a provision in section 2 intended by the legislature to allow for flexibility in interpretation and indicates that the definitions given therein should be understood in accordance with the surrounding context or specific circumstances, rather than strictly adhering to a literal interpretation. This provision hence enables courts to consider the broader context, including the intent of the legislature in determining the applicable meaning of the provisions at hand. In a sense, it grants discretion to interpret the provisions in a manner that best aligns with the overall purpose and objectives of the statute. Para 17 is very important. Though it is correct that the power under section 11(6) of the Act specifically vests the powers of appointment of arbitrator in the case of domestic arbitration upon the High Court, this jurisdiction is also limited, as once an arbitrator is nominated, the High Court does not retain jurisdiction. However, as noted in various judgments, if the power under 29A is to be exercised by the principal civil court, though it may be competent to extend the mandate, an anomalous situation would arise if there is a question of substitution, as it may result in an arbitrator appointed by the High Court being substituted by the principal civil court, which would then militate against the stipulation of section 11(6) of the Act. Now, we'll see kindly for a moment, para 19, the conclusion. In the backdrop of the discussions herein above, coming to the case in hand, the decision rendered in magnum opus, which has been relied upon by the respondents, however, comes to their aid, as the arbitrators in the present case were not appointed under section 11 of the High Court, 11 by the High Court. As such, by applying this judgment, a distinction can be drawn to hold that if the appointment of arbitrator is not by High Court under section 11, the principal civil court of original jurisdiction, in this case, the commercial court at Shillong, will have the power to entertain an application under 29A for extension of the term, as no anomalous situation would arise therefrom. As such, by making use of the expression of section 2 of the Act, unless the context otherwise requires, the textual interpretation will be in tune with the contextual one. Accordingly, keeping in mind the fact that the High Court of Meghalaya does not possess original civil jurisdiction, coupled with the fact that section 11 nor 29A6 do not come into play in the present case, as the arbitrators were not appointed by the High Court, the commercial court, being the principal court of original jurisdiction, will have the jurisdiction to extend the mandate under 29A. So, beloveds, the Meghalaya High Court essentially draws a distinction where there is arbitrators appointed suo motu between parties, and their arbitrators are appointed by recourse to section 11(6). So, where 11(6) has been invoked, there, beloveds, the power remains with the High Court. That's what the Meghalaya High Court says. And the facts of that case was, in Meghalaya High Court, facts were that it was a case where arbitrators were appointed suo motu between parties, and in the factual context of that, the Supreme Court has held that principal court of So the principal civil court will have jurisdiction. So, Milords, my humble submission, therefore, is that this distinction makes it clear. And in my case, Milords, the arbitrator has been appointed by a recourse to Section 11(6). And this view having been upheld by the Supreme Court by way of dismissal of the SLP, Milords, my humble submission is that your lordship will...
You are appearing in which case?
In the first item, Milords.
In the first item relates to what?
It's under 11(6), Milords.
For substitution?
No, Milords, for extension of mandate.
Or extension cannot be granted. My dear. So clear. Yeah. In this case, provided the High Court has a objection, this will have to be this. The High Court does not have the ordinary civil jurisdiction. Here is the case. A power under subsection 6 of section is be a consequential power. Investing in the court which is empowered to extend the time, which court has power to extend the time, this is the court. The principal court of civil jurisdiction. If the court finds that the cause of delay is what has less state power has to be exercised by the court which is empowered to extend the time. Even this power, substitution is vested in the civil court.
Yeah, whatever your lordship's view, Milords, will bow down to that. Milords, just for your lordship's assistance, Milords, to assist your lordships, Milords, I have at page 3 of my note, Milords, I have given a summary. Milords, if I may just place it, it is very short summary, Milords, I have prepared. Your lordship will see page 3, page 3 of my note. Firstly,
the biggest defect in your application is that you have filed an interlocutory application in the arbitration petition. So if you wanted any order, you could have filed a separate petition, which you have not done. This is one aspect that we have not gone in. If you wanted extension of time, then you could have filed a separate application. That is separate provision. Why could you file? How could you file an application in this arbitration proceeding?
Your lordship can give me that liberty.
We did not go into that aspect.
In fact, on all earlier occasions, Milords, I have been filing IA. Your lordships have been...
this is not done. This is not done. Separate powers are exercised under separate provisions of law.
Very well, Milords, I'll do that. Milords, I'll file. If your lordship will give me that liberty, I'll file a separate petition.
Whatever, but we must be clear on law.
Very well. Your lordship will kindly see the summary for a minute, Milords.
Tuesday
Milord,
for orders.
I am in the fourth sub-item, Milord.
Yes.
The fourth sub-item, Milord, there is no issue of 11(6), Milord. Here the parties went to the International Council for Arbitration, and the International Council of Arbitration has appointed the arbitrator, Milord. Therefore, I would like to be relegated to the principal civil court, Milord, in terms of that judgment.
There is no question of relegation.
Milord,
you seek withdrawal.
I will take the liberty, Milord. Lordship may grant me in the fourth sub-item, Milord, the liberty to withdraw and approach the principal civil court. Fourth sub-item, Milord.
I'm for the respondent in that particular sub-item.
Yes, you don't have any objection to that?
My lord, we've already got a
89 of
observed your lordship's view now.
2000. And counsel for the petitioner seeks permission to withdraw this application with a liberty to approach the principal court of civil jurisdiction for seeking extension of time of the mandate of arbitrator. Stop. This application is accordingly dismissed as withdrawn. Arbitrator, in the light of the Supreme Court's order, you are seeking liberty in the light of this
I'm obliged.
Supreme Court's order dated so and so.
Dated 13/5/2024. my lord.
Stop. This application is accordingly dismissed as withdrawn with the liberty as sought.
I'm deeply.
Milords, may I make a submission, Milords? Since your lordships are already taken a view in the your lordships, since your lordships are already taking a view, Milords, in light of the Supreme Court order. So, Milords,
No, we have taken a view, we have expressed our view. We
Yes,
have not, see, we had taken a view. We had taken a view and we changed our view. Because before the
Fine.
order, we uploaded the order of Supreme Court came.
my
So
lords.
therefore, we are bound by the Supreme Court's decisions and
Very
therefore.
If my lord's view is, if my lord's view is that it has to go to the civil court, Milords, then in that event, Milords, your lordship will give me liberty also. I'll go to the civil court then, Milords. I'll not.
You are, you want us to put our view first before we give you permission. See, if you want to withdraw, you may withdraw. And thereafter, you may do whatever you want to do.
In that event, Milords, what is happening, Milords, is that the arbitration proceedings, Milords, is getting stalled. So that's the reason, Milords. So, Milords, your lordship can give me that liberty also.
There are, Land Council, IA number so and so. Land Council for the petitioner seeks permission to withdraw this application with a liberty to make appropriate application for extension of mandate of the arbitrator before appropriate forum in accordance with law. So we have not said anything in your.
Very good. Milords, just one factual thing, Milords, I wish to apprise to your lordships is the commercial court, Milords, which is there in Cuttack, Milords, that there, Milords, if your lordships could direct that all these applications that your lordships are relegating should be disposed of expeditiously, Milords, that will help.
That we will do on the administrative side.
Yes. Milords, because what is happening, Milords, there longish dates are being given for even taking up this
will see.
Practical difficulty we are facing, Milords.
We will address that.
My lords, I'm so grateful.
Deeply obliged.
Baki? Yes, we will.
No, the connected item also I am permitted to withdraw.
Withdraw. With the liberty.
One.
What remains? Only one is there.
Withdraw.
Let's say, I'll seek counsel and my senior counselor Leonard Ms. Rath's assistance in this matter.
No, then you wait till Tuesday.
Your lordship.
As requested on behalf of the petitioner, list this matter on Tuesday under the same heading.
Oh, best lords.
Yes.
In this case, I have completed my submission that you may remember that case, the Hindi teachers case, those who are not fulfilling the eligibility criteria as on the last cut-off date. So on last occasion, they made a request for adjournment after hearings.
The second sub item.
Second, second.
On last occasion, Mr. Rautra has also argued extensively, your lordship. Now there are two aspects. There are two categories of
applicants who have applied for the post of Hindi teacher. One is with regard to that they have completed BA in Hindi along with other subjects. And second one is MA.
That or part.
Yes, Your Lordship. Now, I find an affidavit today, Your Lordship.
No, today this is endless. Will not permit.
The only aspect with regard to clarification that 3 of the respondents, they have completed their MA in Hindi. They have applied under untrained category, but still they're
That is different thing. That
the
is
only
different.
thing that has to be clarified, Your Lordship. Factually, I have to clarify
No
that.
affidavit, no further.
That
It
must
may
be there on
Hindi.
record already. Why do you have to file an affidavit?
It's not a record, Your Lordship, because the Honorable Single Judge has proceeded with the fact that aspect with regard to that the untrained has to complete the train within a period of 3 years. That has not been taken into consideration. Only that aspect.
Affidavit, see,
Must have stated.
normally we don't entertain affidavits in writ appeals. We decide the writ appeals based on the records available for the learned secretary. And every day when the matter is taken up, you will start filing, we start
Your
entertaining
Lordship may
affidavit, then it will become intense exercise.
only 3
If you file,
applicants.
if you file an affidavit, then we will have to give an opportunity to them to deal with that. Then they may also file.
Your Lordship may
So-
but I am submitting, Your Lordship, may clarify that if somebody is eligible in terms of the advertisement, their candidature can be accepted or they can verify their candidature.
Even we don't know what we are going to decide.
That is the only aspect which need to be clarified.
This element is
Can I just point out the respondents who are actually MA in Hindi? They don't
MA
need
in Hindi,
to.
BA in Hindi, whether BA in Hindi, that is a criteria. BA in Hindi with MA in Hindi.
The
You may
qualification.
be having Nobel Prize, but that will not make you eligible for this post.
Yes.
So they have all completed that MA prior to the last date of the cutoff of that resolution, Your Lordship.
You will decide what is it.
So that needs to be clarified, Your Lordship. Otherwise, they will be prejudiced because otherwise, that is the only aspect. आपने बोलिए।
Second matter, my lord, second sub item, that is different, my lord. Well, I need to argue, my lord.
Argue.
Only 5 minutes.
Yes, my
Second
second.
sub item,
I am just clarifying my first and second. In first case, that Honorable Single Judge are directed that treating them as if trained, and also further directed, even if they will not be treated as trained, to treat them untrained. So on last occasion, I have turned my lord's notice that they acquired the training qualification after that cut-off date, so they cannot be treated as trained. So far as untrained part is concerned, they don't have that eligibility criteria, that they are not fulfilling that eligibility criteria. That was the first case. In respect of the second case, though there is no provision for, you'll also for a moment you see that advertisement, that eligibility criteria. Holding the first case, that they
First case.
well, that the eligibility criteria, my you also can find it from my case 70. You'll also got it, page 70, clause F, Hindi teacher.
Yes.
Illustrative first part is trained, second part or part. That in respect of untrained. Bachelor's degree with Hindi as one of the optional honors subject with minimum 50% mark in aggregate, 45% SC, ST, PH, OBC, SCBC candidate, and MA in Hindi with minimum 50% mark in aggregate from recognized university. This qualification first they don't have. So far as second case is concerned, he does not have that bachelor degree with Hindi. He's saying he has a qualification that is equivalent with bachelor degree in Hindi. So far as equivalent is concerned, there is no mention that any equivalent will be taken into account.
No, the first thing you are saying he is not qualified because he has less than 50%.
He has less, that he has no bachelor degree with Hindi,
Okay.
bachelor BA with Hindi.
Nor this Rashtrabhasha.
He had that, not the, or
Because it says bachelor's degree or Rashtrabhasha Ratna.
the
No,
second part, not first part. First part in respect of trend.
No, yes, in that only I'm reading.
There is no
That-
Rashtrabhasha.
He is not a trend. Next page 71.
Wait, no, slowly will let us go. Bachelor's degree from a recognized university with Hindi as one of the elective subjects with minimum 50% in aggregate. Or
Yes. That is in respect of trend.
okay.
Then or. Next or. That is in respect of untrained. Let's look at it.
Yes.
Bachelor degree with Hindi as one of the optional honors subject with a minimum 50% mark in aggregate, 45% for SC, ST, PH, and OBC, SCBC candidate, and MA in Hindi with minimum 50% mark in aggregate from a recognized university. This qualification he does not have. In second case, he is claiming that he had the equivalent qualification with BA. So
which qualification?
that her qualification is
BA with Ratna and MA.
he has prosecuted Rashtrabhasha
Rashtrabhasha
Ratna. He is claiming that is equivalent to BA.
Who? First or second?
Second. First, they don't have that required qualification BA with Hindi.
I have applied under the untrained category. My lord.
See, the simple question is
Yes, my lord.
that whether you have Bachelor of Arts qualification or not.
Yes, my lord, I have.
Where is that Bachelor of Arts in your degree?
My lord, that is there, my lord. Bachelors of Arts, no, but my bachelor, I have Bachelor of Arts, but without Hindi.
Then?
Without Hindi. But my lord, the second alternative qualification is, my lord, Bachelor of Arts with Rashtrabhasha Ratna. My lord, the learned tribunal has held that Rashtrabhasha Ratna is equivalent to Hindi, my lord. And I have also MA in Hindi with 50% of mark.
Please, there are two qualifications. You
Yes,
must possess two qualifications.
Yes, my lord.
To qualify under this or.
Yes, my lord.
Right. You should have bachelor degree with Hindi.
With Hindi as one of the subjects.
Where is the bachelor degree in Hindi?
My lord, in BA, my lord, I don't have Hindi, but I have Rashtrabhasha Ratna,
But
which is
listen,
equivalent to
Listen.
BA in Hindi.
Is it mentioned there? Because in the first one it was
Malak-
mentioned.
Malak-
Here is it mentioned?
No, in second it is not mentioned, but in the first one it is mentioned in the
You are
trained
in the
category.
Second category.
Therefore, had that been so, that would have been mentioned in the second part also.
My lord, what the tribunal has held, my lord, the tribunal has held that Rashtrabhasha Ratna from Rashtrabhasha Ratna is equivalent to BA in Hindi, my lord.
See, the tribunal is not between the Supreme Court and
No.
the High Court. All right. Tribunal is not above the High Court. Tribunal might have held something. We can say that tribunal is incorrect. You should not rely on what has been held by the tribunal.
My lord, similarly situated employees, similarly situated candidate, my lords, who possess the same qualification, my lord, BA without Hindi with Rashtrabhasha Ratna, my lord, they have succeeded before the division bench and they have also succeeded in the.
How many criminals have been acquitted, because of lack of evidence? So all the criminals will be acquitted, even if there is evidence.
The Supreme
Yes, my lord, confirmed by the Supreme Court.
Who that?
Jyotismoy Vaidya.
Same qualification.
Same qualification. We are the advocates in that matter.
You are the advocate. Have you checked?
Yes, my lord. If your lordship permit, I will file an affidavit, my lord.
What affidavit?
But
Every day affidavit. Every day affidavit.
My lord, we are.
And you can get the same order from the Supreme Court.
My lord, but they have succeeded before the division bench, my lord.
Terms are clear. Because here, had they not mentioned at all, it is different. Here, for the other category, they have given that.
Well, in the
Equivalent.
first,
But
mainly in
for
the
this,
first
they have
category they have mentioned.
Exactly.
In the
that is
first
the
category,
problem.
in the trend category they have mentioned, but so far in the second category, well, they have
That is
they have
the
not
It is
mentioned, my
not
lord.
that they have not mentioned. They have excluded.
So this is
the
consciously they have
meaning.
excluded. This is the problem.
And my lord, the second writ appeal is out of a review, my lord.
Yes, and there my lord, tribunal held that Rashtrabhasha is equivalent to so and so. Accordingly, we filed and tribunal held the learned councillor could not brought in to the notice of the tribunal that there is to that effect the notification says they will be excluded. So that very notification says they are not equivalent. So we filed a review petition.
No, the order of the review is on Annexure 5.
So that order you filed a review.
Review.
So that was rejected by the High Court.
High Court, Honorable High Single Judge said, no, this qualification is also prescribed. That is equivalent.
All right. Reserved. Yeah, problem.
Pardon, my lord. If the lordship permitted, only I am submitting. If the lordship was.
Second.
My lord. My lord, if your lordship permitted, I will submit one more thing, my lord. This is it's a weird case, say purely discrimination by the authority, my lord. I am for the intervention. My lord, here the cut-off date as per the advertisement, the authority says 28/1/2015. But
You are arguing
My-
which case?
Still mentioning item 2. Item 2, my lord,
Is
mentioned.
a intervention.
Item 2.
Yes, sir.
Yes. What are you saying?
The authorities say the cut-off date as per the notification earlier.
Who are
I am for the intervention.
you are
In the
intervener?
common judgment 557, my lord, where the cut-off date which has been fixed by the earlier advertisement and published in 2014, whereas the cut-off date fixed 28/1/2015. But the authorities has rejected on the application on the ground that the applicant, the candidate, has not obtained the certificate after 6/4/2015. But where the rejection order 6/4/2015, not where mention any advertisement. The ground which has been stated in their rejection order after pass out 6/4/2015. But my lord, here is question, after subsequent corrigendum on past published on 6/1/2016, the date has been fixed on 28/22/15, my lord. But there is no specific on 6/4/2015. In similar way, two candidates has already been engaged where the qualification obtained 6 July 15, my lord. All the applicants obtained the B.Ed certificate 2015 July. Similarly, two persons engaged by the authorities, I have stated in the single bench before honorable single bench, where order has been specifically discrimination, similar putting, who have obtained the B.Ed certificate on July 15. Similarly, all the candidates produced the B.Ed certificate after obtaining the B.Ed certificate on 6th July 15. They have engaged. I have obtained the RTI application.
But why are you an intervener? You had not filed any writ petition or any OA?
Well, that is the common judgment from WPCOAC NOSA doing. The order itself, there are
many single individual writ petitions transferred from the tribunal. All were disposed of by a common judgment.
yes.
And writ appeal filed in the first case only. In our cases, there is no writ appeal. But because this order may affect us, because definitely because a common judgment. That is why our submission. I have also filed a petition for intervention. My last occasion, I have taken note of my submission. Therefore, I do not argue. We have passed the qualification before the cut-off date. Because we are over-aged, I have completed the course and I have also applied within the time. But they have rejected and my lord have opined. I don't know whether that will come in the judgment. My lord opined, yes, we will take care of those aspects. Therefore, we don't have any submission for that.
This is the document I am supplying before your lordship. This is out of some of the candidates, 2 candidates I have obtained RTI information. They have engaged. Same, I have given the qualification.
Don't give it.
Not bad. But you say, for ourselves, it's a purely discrimination. The authorities, on one hand, engaged the similar footing, other hand, we are discriminated. All are aware of overage, my lord. If we will revert from the
Why is he mentioning discriminated? You are saying that you are won before the single judge and state has challenged that. So what is discrimination?
What you want to say,
Huh?
the state government in one hand challenging the validity of his certificate
Yes.
because you have got it after the date 6/4/50.
Okay.
But they have appointed some persons. Those have also acquired the qualification after
Appointed
that cut-off date.
Before
That is what I'm
the
saying.
before the judgment
We
of
can
this
give
court or
them
before that?
liberty. We can give them liberty to remove all persons who are not qualified in terms of the advertisement. That liberty we will have to give. If somebody illegality
Yes.
has been committed, then they will have
No.
to undo that.
No
That
right.
cannot be an argument on negative equality, my lord, my friend.
Therefore,
But only,
my lord.
but only thing we have to submit, my lord, since we have the
and we
qualification
will
by
not
the
say
date.
that remove them, we will say that remove them after following due process, giving them notice, taking their explanation, everything. So if someone is not qualified to hold a post, he cannot hold a post. According to you, they are qualified. We may hold that they are not qualified. We don't know.
So your objection is you've succeeded before the single judge.
Right.
But you are worried that if this is allowed, then your services may be terminated while others are continuing because their
He has not
appointment has not
He
been
got
challenged.
appointment.
He has not got appointment.
He's saying that others have been given appointment.
So we can't help him if he's
Right.
not a petitioner or anything. I was saying he's
No,
apprehensive that he may be affected.
No, not clear.
No, but what is this practice, Mr. Kotia, that you file one writ petition
Yes, that's.
in one case?
Yes.
So those disputes are inter-party.
Yes, madam.
So
But
they shall take advantage of that decision.
Yes.
yes, madam. I'll clarify that perhaps cases.
How many were disposed of by the same judgment? 100?
5 cases.
No, 5 cases.
5 cases.
Only 5?
Only
one
What
five.
is the problem?
They could have filed it.
I thought I saw one judgment where 100 have disposed of.
Professional filed. In my case, I have searched, there is no appeal. 1326, the second case in
This is appeal or writ petition?
this is a writ appeal, madam.
Writ appeal.
This is a writ appeal, madam. My writ petition is the second in that item 132. 1326 is my case. Before the honorable single judge.
If you lordship permit me for a moment, because I've already argued, because my lordship wanted to argue only one thing. So far as number of cases have been disposed of, and one case they have prepared appeal, that is for your lordship to decide whether we can file an appeal or not. That's a different question. But in one appeal, the basis of which this judgment was passed, impeached judgment was passed by another single judge. That judgment was challenged before the division bench. But anyway, that division bench dismissed it on the ground of limitation. I say that we consider. And that has been challenged before the Supreme Court. Supreme Court has issued notice both on merit as well as.
That is material. Yeah, I remember.
Right, sir.
You
That is only I have
went
to
to
argue.
submission.
The other point you must remember, the first point, the judgment of both the single judge. They
Have
said
you
that,
given your note
it
of
is already
submission?
prepared, it will be given to. I'll
Give that.
So that question, you also remember that bracket portion, that untrained person will be given liberty for 3 years to acquire that qualification. The single judge has proceeded, this applies to both, first and second. That is for your accessory.
Give your notes within 1 week. Notes. Or by Friday.
I have prepared it, but I'll give it by tomorrow.
We have heard learned counsel appearing on behalf of the parties. First off, is submitted by them that they shall be filing their respective written notes of arguments by Tuesday.
Yes, sir.
So this case on Tuesday, we will see these matters on Tuesday. We have done so many hearings. Yes.
May I please? Old matter item 3. There's a lot of gamut of facts, but I would like to make it small and short before your lordships. And there are two issues, my lord. One is a procedural issue. Because whether an appeal of this nature, which I'll place to your lordships, is maintainable in the first place. If that not be so, then the issue can be resolved on that point only. Otherwise, Lord, your lordship may also decide on merits alternatively that whether I stand. Lord, the gamut of facts goes back little pre-independence. Lord, there was a estate. It's called Kinjri estate in the state of Orissa. And this estate, the property concerned was sent to Court of Wards for mismanagement. While in the Court of Wards, the property, there was they also had a High Court. They had a decision, and the issue was whether the law of primogeniture, that is, the eldest son will get it, or it will follow the law of succession. That means everybody in the part. That's the issue before now. Then, but in successive civil proceedings, which is there on record, it was decided that this is to be divided. That means the law of primogeniture is not applicable, and the parties are to divide. That means the co-sharers. And the second, Lord, an important facet is that the matter, the land in question was vested to the state under the Estate Abolition Act. And as your lordships may be aware, the same legal there in all over the country. Once the estate vests with the state, it is free from all encumbrance. And after the state is vested, the state shall grant settlement to and the settlement has been granted to all the co-sharers, not exclusively to the eldest branch. But this being the background, what happened, my lord? There is one contesting is open number 4 who claims the law of primogeniture, and he came before this court and he filed a writ petition and stated that the matter which is pending before the property which is in the Court of Wards may be returned. And the High Court, the High Court gave said that you return the property and you can decide on the entitlement. That means whether exclusively to him or to all of us. When the matter went to the original authority, he took into consideration all these relevant facts, including the civil court proceedings, the other things, and the matter of vesting, everything, and decided it will be divided as per the that was that order in my favor. He preferred an appeal to the ADM. Like this Court of Wards in charge was the Tehsildar. He preferred an appeal to the ADM. And the ADM reversed it, which is the subject matter of challenge before lordships. And the Additional District Magistrate reversed it, saying that the civil court's order is without jurisdiction. That was the different findings of the ADM. But the short point before a lordships would be, at least to the best of my knowledge, I could not find it, my lord. Where is the power of the ADM to decide in the first place, an appeal? There is no provision mentioned in the entire impugned order wherefrom he has got this power to decide the appeal as an appellate authority.
So the original order was passed by whom?
The original order was Tehsildar, but the original order was, I'll put to your lordships, was almost like a semi-administrative order of the Court of Wards clothed with the power by the High Court to decide. That means, Lord, what I humbly submit that if whatever, yes, he has not remedied less. His remedy would have been to challenge it before a civil court. If his entitlement is not that he can confer the ADM with the power of an appeal, which he doesn't have. Well, there is no statute mentioned on which there is no provision on any of the provisions of the Court of Wards Act to file an appeal of this nature. There is no statute mentioned.
So under which provision did he file?
There is no provision mentioned. There is no provision mentioned under the act, under the order. No provision mentioned.
When was the order passed by Tehsildar?
The Tehsildar order was passed. Date. And these orders are very long. I'll give you also the date. Here, date. But 93, 3793, the Tehsildar passed the order. This order is of 96. Actually, because there are a lot of gamut of facts, this matter, there are a lot of substitution and other things that took a long time.
Our question is different. If there was no statutory power of.
No statutory.
But what about the board's miscellaneous rules?
The board miscellaneous, but there's nothing, there 207 minute boards that they refer to that in that order, 207 of the, because what I'm saying, Lord, because the Tehsildar is not acting as a Tehsildar. The Tehsildar is acting as a Court of Wards.
No.
Yes. And every order of. Yes.
If there is some provision under the board's miscellaneous rules that any order passed by an officer shall be subject to appeal or his immediate superior shall be the appellate authority, then he might have exercised that power.
Yes.
You just want to know.
Oh, yeah, I could not locate it. But what is it in the order? It is referred to 207 of the revenue case record. But 207 is something else. This records manual. The order only refers to 207 of the records manual. In the order itself says, so let's just get. If you notice that impugned order at page 191 at page 14, 2071 is nothing but maintenance of records or something.
It's a records manual.
Maintenance. Lord, in the entire case, my lord, if your lordship sees 191.
Oh, but do you have board miscellaneous rule? Do you have board miscellaneous rule are there? Orissa.
The records manual, the revenue law.
Board miscellaneous rules. He can apprise your lordship. She is the contesting respondent of
this particular very argument was advanced before this honorable court, before Honorable Justice Chauhan was the Chief Justice. He was hearing this matter, and that objection was overruled. But there is no order, written order.
That's not important. Lord, I don't know.
But I am taking to your lordship. What is the source of power?
If he has, my lord, he can so. My lord,
kindly have a glance to my note of argument. I have attached the Odisha administration of Odisha State Order 1948. In my note, I have appended that. That is
Orissa?
Administration of Odisha State Order 1948.
Where is that?
I have
You have attached it with your.
I have attached to my note.
On behalf of.
What is this convenience compilation or what? Submission on behalf of the.
Respondent number, opposite part number 4.
No, that is the petitioner. So we have notes submitted by the petitioner. Where is your note?
Hard copy is there.
In the first case, there are two cases.
No, there are only one case.
One case.
I would actually.
No, one other case is there. Purchase also filed another.
Petition count.
This is OJC 2347.
Oh, sorry. Lord, there's some properties have been sold. I think I am not, the second case, I'm not aware. First case, you are
This is available in the volume 1 of the local law. Local law volume 1.
File a note of opposite party.
Administration of Orissa State Order 1948, volume 1.
Yes.
Volume 1.
Page 64.
In exercise of the power conferred under Section 4 of the Foreign Jurisdiction Act 1947, read with notification number so and so, the Government of India in the Ministry of State of States, the Government of Orissa are pleased to make the following order for the effective exercise of foreign jurisdiction in Orissa State, namely, Your Lordship may kindly have a glance to para 6C. Revenue jurisdiction is concerning with para 6 revenue jurisdiction C. An appeal shall lie from an order, judgment or decree of a subdivisional officer or officer specially empowered under subparagraph B to the collector, who may either hear the appeal himself or transfer it to an additional collector or to any revenue officer subordinate to the collector and specially empowered by the commissioner to hear the revenue appeals. The collector may withdraw to his file any appeal so transferred. And there is a schedule appended to the order. In schedule 2, to which act this provision is applicable. In the last page of the schedule 2, it has been mentioned the Orissa, in respect of Orissa Court of Words Act 1947, this order 48 of 9.
Which item?
Schedule 2, Your Lordship.
Schedule 2, which item?
Second page, up to 9 that has been mentioned. Next page,
Serial number.
the Orissa, last but one, the Orissa Court of Words Act 1947.
No,
Which
there's a
item?
serial number. So tell us the serial number. Starting from 1, which is Interest Act, it goes on.
Interest Act 1939.
That is 1. Thereafter it goes on.
Sorry, it has not been.
Elephants Preservation Act. We have Guardians and Wards Act.
Administration of Orissa State Order. Internet.
The 83A Act.
No. That item is not there.
Towards last page of the schedule.
Last page
Last page of the schedule 2.
of the schedule. All right.
Criminal law, Indian partnership, factories, payment of wages, Hindu women's, Arya marriage, Muslim personal
The
criminal.
Orissa
labor.
Compulsory Labor Act. Thereafter, the Orissa Court of Words Act 1947.
Orissa Court of Words Act.
1947. Thereafter, the Bengal Embarkment Orissa Amendment Act 1947.
There Odisha Act. 94. Yes. 1947. Oh, there is no serial for that. Then there is some other heading must be there. Bihar and Odisha Act. Odisha.
That's continuity.
So first was Central Acts, then Bihar and Odisha, then Odisha. Provincial Acts, Bengal.
So Tahsildar is sub-divisional officer.
No,
Is the
sub-divisional officer or any other officer. The language employed is sub-divisional officer or officer.
No, but how do you say that this B will come?
Officer interested under this, any of the act mentioned in the schedule, that is one of the act is Court of Wards Act 1947. And since the Tahsildar is not the competent authority, as per the direction of this honorable court, it ought to have been the collector. But instead of that, the Tahsildar decided the matter.
You could have challenged Tahsildar since C. You filed an appeal.
My lord,
Your appeal is statutory remedy.
my lord,
Unless there is appeal is specifically provided, your appeal could not have been entertained.
right?
You are relying on this
Yes.
6.
6C,
6C.
my lord.
6C says it will lie from an order passed by sub-divisional officers.
And other officers,
Just a minute.
sir,
And other officers.
my lord.
Not other officers. It says sub-divisional officer or
Officer
specially empowered under subparagraph B.
B,
All right. Now come to subparagraph B.
my lord.
Subparagraph B says every sub-divisional magistrate and any other officer specially empowered by the collector.
My lord.
So he was not empowered by the collector, Tahsildar.
The collector has appointed by the Tahsildar, because when I approached this honorable court and this honorable court for release of the entire estate, the state volunteered that we are ready to release the court of wards in favor of the party who is entitled for the same. And thereafter, this honorable court passed the order, and the collector was the court of wards. As per his order, the Tahsildar take up the matter, and Tahsildar decided that it should be released equally among all the co-sharers. The entire thing is whether they are equally entitled to get the properties, or by following the principle of law of primogeniture, it is the eldest son of the Jamidar will get the property. The appellate court told that no, as per the custom, the eldest son of the Jamidar is entitled to get the entire property. That is the crux of the matter. When Tahsildar passed the order, it will be divided between all the co-sharers, all the family members. Admittedly, this property has been taken from the father of the opposite party number 4 in the year 1943.
There are two aspects.
My lord.
The nature of dispute,
My lord.
should not be gone into on merits
My lord.
by this court in jurisdiction.
My lord.
Either way. If we have to consider his case,
My lord.
and if we are not satisfied by his submissions, then also it will have to go to the civil court because of the nature of dispute regarding entitlement.
My lord, under the Court of Wards Act 1947, every problem situation has been met there. Suppose there is a quarrel X is entitled for the entire state or Y is entitled for the entire state. There, under section 48 of the Act, the manager of the court of works, the collector, will sought for a opinion from the competent civil court. Under section 58 of the Act, the learned civil court will give an opinion as to whether X will get the property or Y will get the property.
This is what
that is section 58. I have also supplied the copy of the Court of Words Act 1947.
What we intend to say is
My lord.
that such nature of disputes cannot be adjudicated upon in writ jurisdiction. All right, because that will require leading of evidence. So many things. So if according to you, the court had directed court had directed the collector, and the collector, in view of the direction, had appointed Tahsildar, who is an officer appointed by him within the meaning of 6B of the orders of 1948.
My lord.
Then also the collector, after the order passed by the Tahsildar, would have sought opinion of the civil court.
It
That
could
is
have been on my after filing of the appeal or before filing of the appeal. After this honorable court file remanding the matter.
the final decision. According to you, we will be examining those provisions also, the Court of Words Act. In any case, neither the Tahsildar nor the collector could have taken a decision. Even
Right.
even the collector, we will see that provision. Where is that? Plus show us. The collector was required to have the opinion of the civil court.
If your lordship will found there is any error in the order passed by the learned ADM,
There is no question of error or something. It's a
The-
question of procedure.
the provisions I am reading
Let us see that Court of Words Act, which requires the collector to seek
1947,
opinion.
Court of Words Act 1947,
Which provision?
paragraph 58. No, section 58, sir. As per the provision of section 36 of the CPC, the opinion shall be sought. When any question arises as between two or more words of such a nature that an adjudication upon it by a civil court is expedient, it shall be lawful for the court of words acting through the collector of the district in which a case might have been stated for the opinion of the civil court with regard to such matter under order 36 rule 1 of the fact schedule to the Code of Civil Procedure 1908 to file in the civil court having jurisdiction a statement containing the point or points for determination.
Matter probably requires deeper introspection and tell you what is why. Because this should arise 58 because if it's a ward is defined, my lord, ward. If there is a dispute when a question arises between two or more wards, WARDS, wards has been defined. E, 4E, a person who is under the charge of the court or whose property is under such charge. So, I'm not be able to assist your lordship totally on this line because what would be an appeal? What would be the nature? But in any case, my lord, the matter ought to be, if there is a list or decision, it is the civil court which has to decide ultimately, not the.
Section 52 creates a bar for civil suit by the parties.
No, referred by the collector. Referred by the collector. So,
Section 52.
See what prima facie we have been able to understand is
My lord.
that in this case, this Odisha Court of Wards Act shall apply.
that possibly yes, but only thing, my lord, my duty to point out to your lordships. This was attached in 1943. I don't know what was that year, but this act itself came into force in 47. But my this property was attached before that. Much before that, 43 or something. Whether it could be applied, but there is no other. It could be because
Previously,
what was the? I am not aware of that. What was
my
that?
lord, previously the field was occupied by the Central Province Court of Wards Act 1899.
That thing.
It
I
was
forget.
within, and that 99 Act has been repealed by 1947 Act.
Yes, could be, my lord. Your lordships are right to the extent. I think there is no other field statute except this Court of Wards Act. Presently, it will be applicable. But I just said that
After Section 76, schedule enactment repealed. There were 3 enactments. One is
Therefore,
yes, your lordships are right. The
This
Court
will
of Wards
apply.
Act it has to be the prevailing.
has to be
will
applied.
apply. This is
Yes,
one.
apply.
All right.
Yes.
And possibly because of this, the High Court had required the collector to pass an order. What is the order of the High Court?
Yes, yes.
Order of the High Court I have annexed. Not order of
Annexed
the High Court,
11.
sent back to the collector to decide the matter of return and decide the entitlement also.
It's the appropriate authority to decide.
If lordship's order is High Court is there, your lordship would like to say page 166.
172, the appropriate authority
Yes.
is called upon to give an opportunity of hearing to all the parties concerned and thereafter shall dispose of the matter in accordance with law.
Yes, my
Page
lord is right.
170.
My lord is right. 172. They directed that all the claims to be considered and the appropriate authority at 172. The appropriate authority is called upon to give an opportunity of hearing. I have a good case on merits also, but I thought if your lordships are going to decide or not decide on that account.
Even if you may have a good case on merits, but the question is whether we should decide that.
Yes,
or not.
that's the reason I just didn't want your lordship to disturb all the facts and merits before going into the issue of what should be the scope of decision, which authority should decide. That's the reason I pointed out first.
Even before the appellate authority, they did not raise any objection.
These are matters of
If we did not have the basic
Yes.
jurisdiction, then it has no value.
No, my lord, as per this Administration of State Order 1948, there are several judgments of this honorable court.
Whether Tahsildar had any jurisdiction to decide the dispute. Yes or no?
In fact, as per the statute,
did not
it
have.
is the
He did
Tahsildar
not
is
have.
not.
So, an appeal was preferred against the order passed by an authority which did not have the jurisdiction to decide the dispute.
Right.
There is also a dispute as to whether in such situation the additional collector did have any jurisdiction or not.
Right.
Thirdly, the collector appears to be the competent authority.
Right.
Under this
Court of
act,
Act 947.
who could have in in case of any dispute,
Right.
Refer the matter.
refer the matter to the civil court for opinion.
Right.
Not for
Decision.
adjudication. Final adjudication is of
The collector.
Court of Wards,
The collector.
Commissioner.
Here is the collector.
No, commissioner, as per the act, my lord, as your lordship is right, I saw it to be commissioner.
Commissioner is the Court of Ward, but
the collector.
Commissioner has to take this Court of Wards question related to nature of adjudication, civil court. It shall be lawful for the Court of Wards acting through the collector of the district
Right.
so the Court of Wards shall seek opinion through the collector of the civil court.
Of the civil
And
court.
then the Court of Wards shall
Shall
decide.
Take a decision.
This
Right.
appears
This
to
is
be
this
procedure.
appears to be the procedure.
This appears to be procedure. Please,
Right.
we are agending the matter
Yes,
because we have one confusion.
Right.
yes.
When you refer to the definition wards, all right, ward has different. So there is difference. If there is dispute between two wards, and if there is difference with some dispute between two persons, all right, like which principle will apply? So it's whether it's a dispute between two wards, because ward has been defined
4A, 5A.
4E, no? 4E, sir. Ward means the person who is
E
under
is the-
charge of the court or whose property is under such charge.
or whose property. All right,
So,
all right. What it will come?
so it will be whose property means not everybody's property, so everybody's in ward.
property. Whoever claims.
Whoever claims is in ward.
Whoever claims. Right.
So that could.
Here the words, according to me, is the original words was the father of the opposite part number 5. From
We will
whom the
not go
property was
into-
taken.
We will not go into A, B, C, D, F, nothing. We will just see whether the procedure which was adopted was proper or not. And if required, we will pass orders accordingly.
Yes, sir.
All right.
Yes.
Just assist us. 1, 2,
Okay.
3.
Yes, yes.
See, here the process starts from an order passed by the High Court. That order goes to the collector. Collector thinks it proper to ask the Tahsildar to, don't know what, pass an order, submit a report, examine, verify anything. Tahsildar takes a decision that is treated as an order. And that order, by taking aid of that 6B or something,
The
of the
Tahsildar by
Odisha
then,
record manual.
Tahsildar by then was the manager of the Court of Wards. He was to look after the property and he was putting the properties to auction, collecting the rent, and also he was getting something extra benefit in addition to his salary
So
as the manager of the Court of Wards.
matter was decided by the, also you can rightly put it, the matter was decided by the manager.
Manager, yes.
The Tahsildar as the manager
Tahsildar, in fact, collector could not have asked Tahsildar
to decide
to decide.
the first place.
The collector had to act under the under the orders of the Court of Wards, that is the commissioner.
My lord, immediately after the judgment was passed in the previous writ petition in 1985, they approached to the Tahsildar.
No, that's.
And
Let's
on
not-
their
no,
approach,
let's
the
not-
Tahsildar issued the notice
Let's
and
not get into those facts which are
That-
not
just-
relevant.
Just because they wrote the Tahsildar doesn't get jurisdiction.
So this is 1, 2, 3, 4 steps.
Yes,
Oh,
sir.
oh, like
Alright.
it.
So your lordship.
Tell us and
So
pass on.
it in fact would be very, I mean, as an officer of the court, I can tell, we're very grateful to your lordships that if your lordship can close this pre-independence case.
Let's see.
And the property in the meantime, I mean, has properties have
Yeah,
been sold and other
that
things.
part. Another thing, the property including movable and immovable properties, even if the gold ornaments of the mother of the UP number 4, guns, and several other
That's
things
your lordship will decide.
have been taken to the custody of the Court of Wards.
Unless,
Nothing is available. There is several orders passed by this honorable court. Justice Chauhan also
no,
passed some order You produce the list of properties.
In
It is
fact,
not available
in
because
fact,
it is of the year
I don't want to
1943.
create
Let us go by
merits in law.
Let us go by
Merits
the-
in law.
The procedure of
Yes, sir.
legal
Sir.
procedure,
Oh,
whatever
okay.
is prescribed here.
I don't know for what purpose. Sometime in 2023, there was an order by the National Court to produce the valuation of all the properties. I think maybe there was
No,
a talk for
actually, I
settlement or not.
my
I
lord,
don't
I
know.
was not getting into it, but the state should slightly lie low in this matter. I'll tell you also why. During the management of the Tehsildar, there was properties have been sold. And that's the reason, my lord, the Chief Justice Muralidhar had directed cause an inquiry how the matter sold and called upon the state to file an affidavit. So I am not also taking to your lordship to that arena of facts where that how the property has been sold or disposed of by parties with them and the state and the Tehsildar. That is a different area. So since that will again take
State has never sold it, below.
No, state has
State
not.
has never sold it.
State means the Tehsildar. The
Tahsildar has never sold it.
No, he has
Person
permitted.
in whose name the RO was
that-
separate
that-
in 1942, he had sold it. That was also
He had-
disclosed in our affidavit.
So
So given the
he has sold it. So that in fact your lordship may touch on it or not, that's a later matter, but let it first.
My duty is to bring to lawsuit notice that this order was passed. I have filed an affidavit.
See, the dispute is inter-party,
Yes.
private.
Yes, ma'am.
That will have to be adjudicated upon
Right.
by appropriate.
Yes, that is the gist of the issue. That's the gist of the issue. Who is to decide the inter-party rights and the original civil court? Is the manager of the Court of Wards is competent to decide, and a self-assumed appellate authority can decide. That's the point before lordship.
So you have to just, in fact, the things are clear all.
Yes,
Obliged.
what's your
All
lordship?
right.
Next week, your lordship.
1 week time. Your lordship grant.
But kindly fix a date so that we convenient.
As jointly requested on behalf of the parties, let's this matter on next Thursday. With the first 5 cases,
Your lordship, think this Thursday?
this Thursday.
Grateful. Sir.
Just give us the sequence.
Next week. No, sir.
Give us the sequence of events.
I have, no, I have, in fact, I have got it. I didn't give it to your lordships because of filing system. I'll give it to courtmaster who can bring it on record. Just today I'll give it.
Already date.
So that we can dispose it off on the
Yes,
next.
yes.
I have
I'll
also
give it-
filed. I have also filed a
I'll give it
date
to him.
chart come note.
I think 2-3.
2-3 pages.
2-3 date charts are there.
I have.
By them only.
Course of time, what happens will, my lord?
Your date
Course-
charts
With
are
the
there.
course of time, the matter is taken time and again, one date chart and another date chart. The date chart gets improved and changed.
Better and better.
Grateful, sir.
But I hope it's not longer. Okay.
There are 2 matters.
Yes, ma'am. Item number 4.
I am taking up all matters, right?
In item 4, Lordship, the second item, that is OGC number 2282 of 1990. Lordship, I am praying the name of Mr. DP Dal and Associates kindly be deleted. The matter has already been transferred.
Matter has already,
The brief has already been transferred from us.
So what is this matter about? You are representing whom?
Lordship,
island transfer.
Mr. DP Dal. Senior.
Second.
Petitioner in the second case.
Yes, Your Lordship, in second case.
And who is appearing in the first case?
The power source JM Mohan.
Huh?
The power source JM Mohan.
In the?
Sorry? In the. Original counsel is Mr. J.M. Mahanti. And where is the counsel for the CBI? Where is Mr. Naik, Sarthak Naik?
Your Lordship, I'm appearing on behalf of Mr. Sarthak Naik.
All right.
Yes.
who is appearing for? Where is Mr. Nayak?
Your Lordship, Mr. Naik is on his legs in another court, Your Lordship. In this matter,
What is this case about?
Your Lordship, Mr. Naik was appointed as the retainer counsel in the year 2020, Your Lordship. Since this is an old matter, we do not have any instructions with respect to the
Not
present matter,
instructed.
Your Lordship.
Don't you have the file?
No, Your Lordship, we don't have the file.
Yes, sir. This is despite repeated calls, there is no representation on behalf of the petitioners. Stop. These applications are dismissed for default. Stop. We make it clear that the parties shall be at liberty to apply for a restoration of these applications if situation so warrants. Stop. Let a copy of the agent order be communicated to the address of the respective parties.
This is upon letter of one person. So if he wants to pursue, then.
Association.
No, here written on the High Court. This is at page 20. Register as deputy.
Whether any petition is there, no petition is there.
No, we got letter and. Second one is. Direction to the crime branch to take over the investigation. Mr. Samantra, the second case, first one CBI was the party, second was the crime branch.
I'm not sure it has been handed over to the CBI.
Ultimately. Okay. 26/2/99, CBI was asked to file the report.
9/1/2019, 1/2000, 19/11/2001, Your Lordship, was transferred to CBI.
The second CBI is the petition.
But you order the transfer it was. Order date 1911 na.
Direction for handing over investigation.
So data can order the produce and the
No,
number 26.
Direction, if it has been handed over, then that.
And what is the significance? No, this is in 19. Close country. It has been handed over to CBI.
Yes, Your Lordship.
Order number 23 you also will look at.
Second repetition.
Second also, Your Lordship, on 7.
You're asking about the second.
2001. Second 2282.
Yes,
Your
yes.
Lordship. There also the CBI was.
Order.
Latest status report.
CBI had been asked to hold an inquiry, 26/2/99, and file a report.
Then 17/8/20, 2001 also it was asked to file a status report, latest status report.
And who is for the CBI?
CBI counsels have changed since then. Now it is Mr. Naik. Who says it doesn't have any records? But if you are counsel for the CBI, how can you not have records? You're supposed to get the records from the CBI.
Your Lordship may kindly grant 1 week's time to get the records from the department, Your Lordship.
When you got the brief, you should have got the records.
Your Lordship, since it is an old matter and it was only in the list yesterday, Your Lordship, we have informed the department about the
Just a
matter.
minute. Not a question of coming in the list. When you got the case and you're appearing, then how come you don't have the records?
Your Lordship, some time may be given to get the records, Your Lordship, and present the latest instructions in the present matter.
These applications are pending for last more than 35 years, 25 years. Oh, stop. There is no representation on behalf of the petitioner in second case. Is not on behalf of the petitioner in GST number 2282 of 1990. Stop considering the matter relates to criminal investigation into killing of a child.
Yes, Your Lordship.
In the year 1997. Stop. Considering the long pendency of this matter, we close the present two cases, liberty to the parties to approach this court if any situation so warrants. Stop. Next. We have been informed that CBI has already taken up investigation into the case. So,
it has already been filed, but copy has been served today.
Yes, I received it today.
what is this about?
This is that land acquisition matter, my lord, where your lordship's
Land acquisition matter, my lord.
lordship's attention was drawn in the last occasion, saying that in 1983, I have purchased a land, and they have issued a notification under Land Acquisition Act in 84, saying that to acquire the land. They have acquired it. Subsequently, they have said that we don't want it, we want to denotify the land. So thereafter, then this honorable court said that if you are to denotify, survey it and give it back. That they didn't give. Thereafter, now they are coming up with a plea saying that my sale itself is not valid, all those things. So therefore, counter, rejoinder, everything is ready. Just now, my friend has given me the counter of the housing and urban development. So I will respond to it and also give a detailed note so that it can be disposed of.
It is stated at the bar that a counter affidavit is going to be filed.
No, already filed, my lord. Now copy has been served by opposite partner 1, my lord.
A counter affidavit has been filed. That a copy of the counter affidavit filed on behalf of the
Opposite partner 1, my lord, Secretary Urban Development.
number 1 filed in this case has been served upon learned counsel for the petitioner today. Stop. and senior counsel appearing on behalf of the petitioner seeks adjournment to consider the said counter affidavit and file rejoinder if so required. So, as requested, list this matter on
1 week after.
2 weeks. Yes.
Counter affidavit of 2017, that copy you have served.
No, I have given one copy
Yes.
2017, all right, got it.
Item number 6.
Okay.
Your Lordship, item number 6, I am for OP number 1 on behalf of Mr. Jayat.
Please. Whether the cause of action survives.
Pardon, Your Lordship.
Whether the cause of action survives.
Which matter are you appearing?
Your Lordship, item number 6, part 1, WPC 3446 of 2002.
On behalf of?
On behalf of Mr. Jayat, Your Lordship.
Mr. J.R. Das is not there in.
For OP number 1.
All right, OP number 1. Mr. Samantray, the prayer is that they will dispose it of again afresh. Prayer
In fact, there was a direction to serve a copy, even copy has not been given to us also. We are state is a party, but
state is a party, it is there since 24 years, 20 years.
yeah. So because it's between,
You don't have a copy?
no. So
State may not be a party also. But there's a direction to the state. They have not implemented the state as a party,
no.
but the prayer is that the Tahsildar should. Prayer is that Tahsildar should dispose of without making the state a party.
Pardon, Your Lordship, I think opposite party numbers 6 and 5, 6 and 7.
5, 6 and 7, all right, let me check.
Okay.
Yes, yes. 5, 6, 7. You're right, you're right. Then copy must have been served.
Not available, I will get it from my friends. I think Mr. Guru Dutt Kaur should, because Mr. Prahlad Kaur should not be no more there. So Guru Dutt Kaur should appear in this case because it belongs to his office.
Law of succession, it must have got. Other names also, he might have succeeded to the bank cases, but these cases may not be giving attention. Any other counsel amongst them who's
Don't think not so. Jay Bera is no more there. Bishiswai P.K. Malik, Pramod Kumar, they are all independent now.
2, 3, and 4 is fine. Mr. Das is for whom?
OP1, Your Lordship.
You are for 2, 3, 4.
Purnachandra Das.
The number 1 had died. Petition number 3 has been substituted in the first petition, but
Transport.
How this petition has been filed by the DT when the order is in favor of the DT?
Bit afresh after taking into account all the properties in 3 villages. This prayer is a bit afresh after taking into account probably some property has been left out. This prayer.
As requested on behalf of, there is no representation on behalf of the petitioners. List this matter on next Thursday.
Right.
Item number 7.
Bless you.
Mr. Samantra, if possible, inform Mr. Kaur.
I will inform.
Item 7.
This is a PIL matter. no?
Yes, yes.
This matter appears today's release as per order dated.
So now whether something is required to be done, they have now.
And for installation of insulator in 3 hospitals matter. I may be permitted to draw your lordship kind attention to the relevant order which has been passed by this honorable court, which has not been complied with by the opposite parties. That is the order
Order number 111.
no, order number 111 dated 7/8/2023. As per that, this is
Mr. We should take care, we should take care of all, should take care also of a situation where we are not appointed as the superintendent of medical college. We are the High Court judges. Okay, see, I'm seeing 111th order passed in this case by High Court. Let us see your prayer.
I may be permitted to draw your lordship kind attention to relevant order matter.
Let's see
An
the
order
prayer
which
then.
has not been complied with.
Let us see the prayer first.
Modern plants or machines, incinerators. You have prayed for closure of these hospitals. Can the people survive if these hospitals are closed?
Our limited prayers for this honorable court.
No, look at prayer number 2.
For installation of insulator.
Prayer number 2.
My lord.
Your prayer number 2. Oh, you have said not to proceed with closure. All right.
I may be permitted to draw your lordship kind attention to order dated 14th September 2022.
See,
As
this
I-
writ petition, this writ petition was filed in 2003.
My lord.
We are in 2024.
My lord.
In the meanwhile, they are coming up with a new hospital altogether with all the
Facilities.
all facilities, all infrastructure. We should close this.
And the Taladanda canal, you have seen what has happened. So
Right.
prayer number 4 is infructuous.
Our limited plan for installation of new insulator in 3 hospital. My lord. For that reason, this honorable court has directed the petitioner to visit the hospital and submit a report. As per that direction, we have already submitted a report and they are required to comply.
So when had you submitted the report?
Report, my lord. Affidavit, my lord, filed by the petitioner on 11/11/2022. That is at flag 110, my lord.
After that, this modernization has started and progressed to a great extent.
No, my lord, as far as the new building is concerned,
Yes.
building is concerned, their insulator was defective and this honorable court has passed an order
Incinerator or-
on 28
Incinerator.
insulator for disposal of biomedical waste, my lord.
Yes, yes.
For that reason, this honorable court has passed an order on 28 March 2022 in order number 103. I will be permitted to draw your lordship kind attention. Order number 103 dated 28 March 2022. On that day, this honorable court has directed 103 mail dated 28 March 2022.
Yes.
On that day, this honorable court has directed the opposite parties to procure new insulator for 3 government hospital. May I place that order? My lord? Order number 103 dated 28 March 2022. For that reason, this honorable court wants to know whether the new insulator has been procured and installed. For that reason, petitioner was directed to visit the 3 hospitals and submit report. And now the superintendent of all these hospitals have said that the new insulator has not been procured.
Mr. Mahanti, one moment. You are referring to order dated 28/3/2022. In that order of the year 2015 was referred to. Order of the year 2015 has been referred to, and it has been stated that order dated 19/9/2020, 2014 has not been complied with. So thereafter, this new hospital thing has started.
New hospital has been started by law.
Yes.
As per the whole building is concerned, insulator is required. For that reason, this honorable court has passed that order for procurement of new insulator, madam. For disposal of biomedical
Come
waste.
to 106, order number 106.
My lord. Order numbers are 106 dated 14/9/2022. Relevant paragraph of the said order is at para 3 and 4, my lord. I would like to place para 3 and 4, my lord, if your lordship permits. London Council appearing for the petitioner, on the other hand, insists that the order dated 28 March 2022 of this court has still not complied with, and that the affidavit filed by the state is silent about the repair of the Bokum insulator installed at the SB Medical College. Para 4, my lord. The court considers it appropriate to permit the petitioner's representatives so and so, and within the next to visit the SB Medical College and Hospital within the next 2 days, 2 weeks, with at least 1 week's advance notice to the medical superintendent, the superintendent of medical college, so and so.
What do you want?
Explain, my lord.
What do you want?
My submission we want, the petitioner wants that the new insulator should procure and install.
New
Three,
incinerators should be
procure and install. In three,
and installed
my lord, in 3 hospitals.
in 3 hospitals.
For
Which
that
are they?
reason, this honorable court wants to know
Which are they?
that is SB Medical College, Cuttack, Vimsar, Burla, and MKCG Medical College, Varampu. This honorable court also wants whether that has been installed or not. Whether order dated 28 March 2022 has been complied with or not.
All right.
That is our limited prayer.
We are directing them to do it.
My lord.
That's all.
Now, so far as Barampur is concerned,
Yes.
an affidavit has been filed, not on 19/8/2023, that a new machine has been procured and it has been installed, it shall be operational. Because they have returned to the PCB to inspect it and that will be done. That was an affidavit filed by the followers. So far as Burla and SC is concerned, you can direct, if not done, you can do it within a limited time. No.
SCB Burla?
No, SCB is Cuttack.
SB Medical College, Cuttack.
And Vimsar?
At Burla.
Burla.
Sambalpur.
No, what is you have not installed?
No, that affidavit we have not filed. We have filed the affidavit of Barampur only. So far, Cuttack and Burla is concerned, we have not filed that affidavit.
But already the superintendent of 2 hospitals have said that they have not procured. That affidavit is also there.
You are directing them.
My
Yes,
lord.
yes, ma'am.
And disposing the writ.
Yeah, some different size.
The petitioner in the present writ application
Oh God.
in the nature of public interest litigation has raised a genuine public cause of proper disposal of biomedical waste
My lord.
in SCB Medical College, Cuttack, Vimsar, Burla, full form of the whole hospital, I don't know, and MKCG, Behram, by installation of new incinerators and ensure that, and by ensuring that the incinerators, such incinerators are functional. So stop. This matter is pending since 2003, has remained pending for more than 21 years, and 111 orders have been passed till date.
My lord.
So stop. It is not in dispute that in view of that because of the court's intervention, this court's intervention, new incinerator has been installed in MKCG Behrampur, which is said to be functional also.
No.
Full stop. The requirement, there is no dispute that it is essential for proper disposal of bio-waste in medical colleges is essential. That it is essential. But it is not in dispute that there is necessity of installation of incinerators in other two hospitals. We may refer to this court's order passed earlier on 28/3/2023, which reads thus. First off, the matter was later taken up on 14/9/2022 when this court recorded following order. First off, from the order dated 14/9/2022, it appears that the Additional Chief Secretary, Health and Family Welfare Department had stated in his affidavit that the incinerator under Biomedical Medical Waste Management Program was fully functional at SCB Medical College, Hospital, Cuttack, with a login ID and password from the State Pollution Control Board. Stop. It was also stated that incinerators in two other government medical colleges and hospitals, that is Behrampur and Burla, had been connected to SPCB. What is SPCB? State Pollution Control Board portal. So stop. Next. In such view of the matter, we dispose of the present writ application with a direction to the Additional Chief Secretary, Health, Family Welfare, so and so, to ensure that incinerators in all the above mentioned three medical hospitals are functional. And if required, new incinerators be installed. Full stop. The court may take serious view of the matter if this court's direction is violated in any manner. Full stop. This application stands disposed of accordingly. You can file a contempt. There are other prayers. There is another prayer made in the writ petition
Pertaining to Taladanda Canal.
pertaining to
Taladanda Canal.
Taladanda Canal, which prayer has admittedly become infructuous. So, this application stands disposed of accordingly with the requisite direction and observation.
Specific date may be given so that within that time they will be installed.
You do it. Do it. You can tell
This case, how can this be 2015 incident?
Because of absent
Yeah, that is always open. No cause of action, new petition.
Item number 8.
May it please. On the last day, the Honorable Court has directed the parties for the negotiation by the order dated 26/9/2023, but till date, no negotiation has taken place due to their honorability. So I say that the matter may be adjourned to some other date so that they would negotiate the matter and settle the if possible.
What negotiation?
Please, Your Lordship. Milord, I appear for the respondent number 1 and 2, Milord.
Who are they?
The Hindustan Petroleum Corporation, Milord. We have taken his lease land for a petrol pump, Milord, and it's been continuing for a long time. The dispute herein, Milord, arose relating to a dispute on the quantum of the rent. This Honorable Court, entertaining the writ application, Milord, directed that the current market value rent be deposited, and Milord, pursuant to Your Lordship's kind intervention, Milord, we deposited the rent and rent has been dispersed to them. In the meantime, this Honorable Court directed that you continue to pay this rent and negotiate with him for a fresh lease. Those lease negotiations, Milord, I'm instructed, are still on. Milord, hence, Milord, the joint prayer that the matter be adjourned for at least 4 weeks, Milord. We will come back and report to Your Lordship as to the development.
No, we will not adjourn for 4 weeks. We can adjourn for 2 weeks.
As Your Lordship pleases.
You do it.
Milord, very well.
Otherwise, it is very embarrassing to see that 2004 matter is pending.
As Your Lordship pleases.
As jointly requested on behalf of the parties, so as to explore possibilities of amicable resolution of dispute, list this matter on 2 weeks.
Item number 9. Lord, may I just pray, Lord, could it be in the week of 20th August, because 2 weeks, Lord, will come up on 16th. I have a difficulty on 16th, Lord. Thereafter,
Will come up on 20th.
20th, 21st, 21st. 21st. Deeply.
9, my lord. I mean item number 9. May I please, your lord?
Yeah.
Yes.
Item 9.
My lord, item number 9, I am in BC, my lord. My lord, here is a case. This writ application was dismissed on due to non-appearance. Subsequently, it has been restored, my lord. This is a matter, my lord. Am I audible, my lord?
Yes, we can hear you.
My lord. This is a case, my lord, where the petitioner was allotted a plot in 1998 by Rourkela Development Authority. The allotment order is at page 6, your lordship may see. It's a plot which was allotted for the purpose of construction of a restaurant on self-finance scheme. Then, my lord, subsequently, when the land was allotted, the possession could not be given to the petitioner by Rourkela Development Authority because some portion of the land was occupied forcibly by some other persons, my lord. Then, my lord, your lordship may turn to page 17. Page 17, my lord, the cancellation,
Mr. Counsel, when was that plotted? When was the plot allotted?
Plot was allotted in 1998, your lordship.
All right. So, when did you approach the court?
In 2004, my lord.
Why? 6 years thereafter?
Because I am coming, my lord. The plot was cancelled in 2002. Subsequently, because I couldn't take possession, the possession was not given to me, I ran before the authority. And every time the authority tried to give possession.
Where is the order of cancellation?
My lord, as page 17.
Annexure 2.
Annexure 2, your lordship. That cancellation of the plot was on the ground that within 6 months I couldn't construct the restaurant over the plot.
Yes.
Subsequently, I'm coming, my lord. Subsequently, I filed representations. I informed to the authority that under what circumstances I couldn't construct the land, construct the restaurant, my lord. Then your lordship may see space 10. I am sorry, it was actually wrongly.
No, so the
Yeah.
order was withdrawn. Thereafter.
Order was withdrawn, my lord. Order was withdrawn. Your lordship may see the contents of the withdrawal order.
Final decision will be taken. So, part of annexure 1 is will be.
My lord. The cancellation of allotment may permit permitted. My lord. The cancellation of allotment of commercial space bearing so and so area so and so near so and so issued by this office letter number so and so dated 28/5/2002 is hereby withdrawn. The matter will be placed before the authority for final decision. Then, my lord, page 19, your lordship may see, the Rourkela Development Authority made and published an advertisement for fresh allotment of that particular plot, which is under challenge, my lord. And because of the, by the grace of this honorable court, the till date, my lord, the plot is lying vacant. May I pray one thing, my lord, since the plot is lying vacant, I am ready and willing to pay the current market value. Your lordship may direct disposal with a direction that they will calculate the market value. I will deposit the market value also. Just
My problem is I have a development authority. I have got this land from as a lease from state government, making payment of premium. From 18, no revenue is collected from this particular plot. Is like allotment was he has to construct building for 6 months within 6 months and pay license fee thereafter. Since 1998 till date, I am not getting a single revenue.
You can.
Position. There is no encouragement. He has not kindly refer to page 3 of my counter affidavit. There, my lord, the chairman has observed that what step he has taken, my lord. Kindly page 3 of my counter affidavit. Towards bottom.
But is the plot vacant as on date?
Yes, my lord.
Just a minute, let him say.
Sorry, my.
Page 3 is illegible.
I am eager to collect revenue.
Which paragraph?
Paragraph in the middle portion, the quotation portion from the facts. You also got it. Middle of the page 3. The order portion I have quoted.
Oh.
From the facts of the as stated in file, it appears that Sri Samantraya Senapati has not taken interest in taking over possession of the allotted land. He confessed before me that seeing the allotment of a land, he never approached the RDA to hand over the possession. On his behalf, somebody else came to pursue the matter since 2002 only, without any power of attorney or authorization. In view of this, I am inclined to believe that said land allotted in his favor shall be cancelled and his amount be refunded to avoid further litigations. Please expedite the matter and put up accordingly. So naturally, he has not taken up any steps, man. I am losing revenue. I am eager to give it on license basis to somebody else so that I can collect revenue, and I am regularly paying government the land premium and the cess. I am regularly paying, not getting a single revenue from it. I am a developer authority. Government of Odisha has leased out this particular land to allot and collect the money and pay to the government. I am paying to the government, but I am not getting the revenue. I also
You are paying to the government, but he is ready to give everything.
Pardon, my lord?
He is ready to give. He is ready to compensate.
Yes, my lord, all these license fees of all these years and the present current market value, I am eager, my lord. I am much obliged, my lord. I want revenue, my lord.
So are you ready to pay?
My lord, I am ready to pay the current market rate, market value, my lord.
Market value plus
My lord.
plus what?
Revenue, the license fee.
All these years.
Plus the license fee for all these years.
All these years license fee, my lord, it will be a little bit heavy because they couldn't
Market value
give.
will be more, license fee will be less.
Because my office sustains from these license fees. I don't
Because
get
they
any
have
aid
also
from government.
just a minute. Because they have also kept my 28,000 since 96, my lord. That
Yes.
I
That is
my
security
lord.
put.
Mr. Misra,
My lord.
happily they will return it to you with interest.
My sir. No, my lord, I am ready to pay. My lordship may observe. I am ready to pay.
Yes, ma'am.
Uh,
And your lordship may kindly stipulate a particular time period because after litigations.
No, first you give.
One.
Learned counsel for the briefly narrated. It is the petitioner's case that plot number, that commercial space bearing number C/1 in area 7 and 8.
My lord, 7 and 8.
Listen to rural center.
Fuel center.
Fuel center.
My lord.
At measuring 35 feet into 40. 35 into 40.
Feet, my lord.
40?
Feet.
40 feet was allotted in his favor on a license fee basis for construction of a restaurant. On self-finance basis, subject to fulfillment of terms and conditions of the agreement. Stop. As the petitioner could not construct the restaurant within stipulated time, comma, by an order dated, comma, the Rourkela Development Authority cancelled the allotment by an order dated 28/5/2002. Stop. Later, the cancellation order was withdrawn in the year 2004.
2002, my lord. 56.
Cancellation withdrawn 2002.
56.
Later, the said cancellation order was withdrawn. Stop. Next.
So Mahapatra, it was
The said plot was later put for auction or what?
No.
cancelled again.
Judgment was
Said
given.
plot was
That was stayed.
again advertised
Again advertised.
by Rourkela Development Authority
In 2004.
For grant of lease, which became subject matter of challenge before this court in the present writ application. Stop. The court, where is the interim order?
Interim order, my lord. One.
The court had court by an order dated 1/11/2000,
111.
comma, while issuing notice to the Rourkela Development Authority, had directed that the said space shall not be sold to any third party. Stop. Since then, the matter remained pending and the case was dismissed on 12/2/2021 for non-prosecution. Stop. Later, the application, grid application was restored to its original file. Full stop. From the submissions, from the pleadings on record and the submissions which have been advanced on behalf of the parties, it appears that there is a dispute. It appears that on the one hand, the petitioner is claiming that because of illegal encroachments caused on the place, he could not take up any work for construction of a restaurant, comma. It is on the other hand, it is the case of Rourkela Development Authority that the petitioner did not do anything in the direction of construction of restaurant, nor did he pay the license fee as he was required to pay. Stop. Next, the counsel appearing on behalf of the petitioner has submitted that as on date, the petitioner is ready to pay the license fee for all these years and the market value of the space.
Hello, one thing may submit my lordships. My lord, if I will pay the entire rent of these years, and I have also deposited, if I would have constructed the building and I would have run the restaurant, then the same thing would have been going on. So if I will pay the rent till today and in future, then on market value.
If your case is fit to be dismissed on the ground that you got stay long back, and
sorry, madam. Sorry, madam.
how can that be allowed? That plot was, that space was allotted to you for construction of restaurant. You did not do that. That was the purpose for which the space was reserved. So the that purpose could not be utilized. So if you are ready, then it's all right. Otherwise,
My lord, I'm ready.
Then council representing Rourkela Development Authority does not have any objection to the offer made by Land Council appearing on behalf of the petitioner. So he, however, seeks adjournment to seek instruction from the Rourkela Development Authority in this. Do you have instruction, Mr.
Regarding the amount.
Amount I will have.
Otherwise also.
You seek instruction and file a short affidavit as to whether the offer made by the petitioner is acceptable or not.
One further point, my lord. Since I am eager to get revenue, I have not pressed it. But another vital point is, after obtaining the cancellation order, he moved the civil court. That is civil suit number 24 of 2004.
That has been withdrawn long since.
Right, Mal. In the civil suit, he got an injunction. We filed the counter expert injunction. We filed the counter affidavit. In the counter affidavit, the injunction order was vacated because by that time the order has already been cancelled. Thereafter, he withdrew the suit and filed the seat application. So, as if challenging the order of the civil court, rejecting the cancellation, as if the writ court is an appellate court.
As if you advertise,
yes,
then you will get the market value.
Yes, ma'am. Yes. No,
and if you give it to him, he will give you the market
yes,
value.
Yes, ma'am. Yeah, I
plus license fee also.
Right, ma'am. That's why I have not. This is this objection I have not. This objection I have not raised because I want revenue.
So therefore, just tell us.
Right.
Lordship, please.
Is this matter on? When?
At least because my law officer is retired, so at least 2 weeks time, my lord.
We are giving you 3 weeks.
Oblige, my lord.
Item number 10.
I am for the petitioner. The Honorable Court directed to verify the village Odange Maligeshwarapur, Gochar land or private property. But till now, report has been not come.
But admittedly, it's a Gochar land. There was a direction to me to find the present status of the land, whether now it is being used for communal purpose by the villagers or in the khas possession of the petitioner, lords, where he has lost before 2 forums of the revenue authorities. And now he has approached the lordships. That instruction was given because we had written a letter to the lords Tahsildar Kendrapada. Now he has stated that due to bifurcation of the Tahsil, now it comes within Derabis Tahsil lords. The ADM has also written to the Tahsildar to give instruction lords, but the Derabis Tahsil has not yet given that instruction. If you also take it up on next Thursday.
No, what is it? Let us understand. 2005.
But is report necessary? Because if orders are there of the authority, report
May
is
not be
required.
necessary because he claimed the land to be in exchange of his private land, and that has been negated by this Honorable Court. This Honorable Court said that no, it cannot be exchanged and directed for disposal of the appeal. Appeal was dismissed. Thereafter revision. Revision has also been dismissed.
But he's challenging only annexure.
And without telling annexure 13, he has challenged only 19. Plus, ultimately, that is of no use.
Because you have only challenged the last order.
It has come to next week. Yeah, I will.
What is next week? This is 2005. We are in
20 years.
2024.
Yes, next week, last.
And what is the as requested on behalf of the petitioner, list this matter on next week. The court makes it clear that no further adjournment shall be granted as the matter is pending in this court for last 19 years, more than 19 years. Yes.
Item 11.
At an item 11, my lord, I am but the petitioner. I pray for an adjournment because the file originally available with Mr. Mishra, my lord. In the meantime, I have entrusted the case, and my lord, Mr. Mishra is not available. So, my lord, I pray for an adjournment, and my lord, the land already settled in the meantime with Lord Jagannath, and that is also challenged in another writ petition connected to the said writ petition, my lord, same writ petition, that is 11278 of 2022. Which is pending before your lordship. So I pray your lordship may call this matter along with this writ petition. It is filed by the opposite party number 1, the self-same property, which is involved in this writ petition. It is also subsequently settled in favor of Lord Jagannath by the Tahsildar, and that is also carried to this honorable court in a writ petition 11278 of 2022. That is my instruction. If your lordship call this matter together, Lord, in the meantime, I will procure the file also, and I will assist your lordship. Because
I am for the respondent 1, your lordship. What happened in the year 2022, the present writ application was dismissed. Thereafter, they have filed same appeal, but copy was not sought to us, and subsequently that was restored. It was not our knowledge, and in the meantime, we have returned the file to my client. That is the But I am also praying some time to take instruction.
And you have filed petition.
The second writ petition has been filed by you challenging the settlement in name of Lord Jagannath.
Yes,
Yes.
You have filed.
yes. OP1, my lord.
Has jointly requested this case on 2 weeks along with
WPC 11278.
of 2022.
Much obliged.
You'll enter appearance in the meanwhile.
Yes, in the meantime, I will enter my appeal.
So,
That
but
case-
now we will take up old matters. We will not leave old matters.
Yes.
So,
Item 12.
So you're on behalf of Mr. Lenka.
My lord.
yes.
Item 12.
This matter, in fact, has come up after a long gap. It's a matter relating to the action of the OSFC under Section 30 of the State Financial Corporation Act regarding the loan liability. And there were two orders of reasonable court, that is order dated that is order dated 27/11/2007 and my lord 30/10/2007. My lord, as to whether this petition has been provided with further financial assistance or not. If your lordship will kindly permit and grant me little time, I can take instruction because the phone numbers which were provided initially at the time of filing of case is not connecting. So therefore, I am at a loss to know the exact status, and I was inquiring from
What dates did you mention?
30/10/2007, your lordship, and 27/11/2007.
If you
And I
don't
was-
have any instruction, don't press.
My lord, one thing, my lord, I beg to clarify. I was also inquiring from the State Financial Corporation Council as to the position. He is unable to say. My lord, what I beg to submit, this is a very small industry. So if your lordship grants me 10 days time, my lord, I can just come back and
On behalf of the petitioner states that since the matter is old and has been taken up after considerable period of time, he needs adjournment. He needs short adjournment.
No.
As requested with the consent of the other side, list this matter on 2 weeks. Is there any interim order?
No, my lord, is
All right, next.
Item 13.
obliged, man. In fact, notice was both on IA and main case, so therefore there is no interim order. I'll just find out.
The matters are there, or all are arising out of same judgment. My lord, I have challenged in part matter, my lord. That's all in all matters, my lord. The judgment of the liquidator.
Rights of the.
I'm coming. Judgment of the liquidator under the Orissa Cooperative Act 1962, my lord, which has been passed under section 75 4A of the said act, my lord, and also annexure 5 that review petition was dismissed. Here, my lord.
Have you given up your challenge to the virus of
Section
section 75(4)? You have given that up.
So
you're not challenging the virus of section 75(4)?
Yes, I have challenged.
You're not mentioning that?
I have mentioned in the writ petition. I have mentioned that. I'm coming to that, my lord. I have challenged that section 75(4)A of the.
If that is valid, then what is your submission?
My lord, prior to going to that fact, my lord, I want to take your lordship to section 75(4)A as that the order passed by the liquidator. Liquidator has no jurisdiction
if I fail to
No,
that
no.
some.
See, there is difference. When you challenge virus of the of provision, then your relief is dependent on the challenge to the validity of that provision. All right.
Yes, ma'am.
So therefore, since you did not press that prayer first, therefore we put this question as
my
if
lord.
that is valid, then what is your stand?
Yes, my lord. I only first I take your lordships to that what I have prayed in the what is
It
the
is very difficult to accept whatever you say. So you will have to say whether you are pressing that
No, I am
prayer
pressing.
or not.
I am pressing that.
So if you are pressing that,
Yes.
then you are under obligation to press that first.
First, my lord. Before that pressing that first, my lord, I want that I place one point that if that I will succeed my on that point, then I will not go to the second point of
Look at your prayer, Mr. Mahanti, section 75(4) of what?
ultravirus to section 14 of the Constitution.
No, but section 75 of what?
Of the Orissa Cooperative Act, that where it has been that.
No, that is all right, but that is not there in your prayer. That's why I asked.
I have prayed, my lord, that sorcery in
It is not there in your prayer, Mr. Mahanti. That is why I asked.
read petition, in the read petition.
Yes, yes.
I have prayed, my lord, Raj.
Turn to page 15, please.
Yes, 15. The
Yes.
petitioner most respectfully pray that the Honorable Court may be graciously pleased to allow the read, issue a read or direction in the nature of mandamus or sorcery or any other appropriate read or direction, declaring section 75(4)(a) as ultra.
Yes, please stop there. You think I ask questions without seeing the record?
75(4)(a) of what?
Of the Orissa Cooperative Society Act. That I have played, my lord.
That I've repeated thrice. You are insisting it is there.
I could not understand, my lord, that what you were.
You could not understand.
That 75(4)(a), my lord, I have not seen that Orissa Cooperative. Sorry, my lord, that Orissa Cooperative Society Act, my lord. You will also kindly come to that provision, my lord, kindly. Kindly come to that provision.
Where will we go?
Section 75, my lord. Powers of liquidator, my lord.
All the three writ petitions same.
All
Same prayer,
the-
same.
all the-
To the joint order,
It's common.
common order.
The liability has been fixed on three persons. They have filed the writ petition. Powers of liquidator, subject to any rule made in this behalf, the whole of the assets of society in respect of which an order for winding of has been made.
You are challenging whole 75 or?
No, 75(4)(a), my lord.
4A, come to 4A.
4, yes. Notwithstanding anything contained in this act, no dispute touching the constitution, management, or business of a society, in respect of which an order for winding up has been made.
Finding.
Under subsection 1, shall on and after the date of commencement of section 41 of the Orissa Cooperative Society Act, Society Amendment Act 1991, be raised before any other authority other than the liquidator of the society, and for that purpose, the liquidator shall have powers to start on his own motion proceeding on behalf of the society. Here, my lord, instructed before going to that virus of this provision, my lord, I want to submit one point, my lord, that the judgment of the liquidator is a nullity without having any jurisdiction, my lord.
Mr. Counsel, please try to understand one thing. When you are challenging virus of a provision, you are not required to state any fact, because that challenge will depend on the constitutional provisions or legal provisions. So what happened, what had not happened, we are not required to look into that. And this practice I am seeing is rampant, that you state your facts, and according to you, if you succeed If you don't succeed on facts, then you want to address the validity. This we are not going to permit. So either you press this prayer and satisfy us, or you drop it and make your submissions on merits.
My lord, I humbly submit before your lordship, my lord. On that provision, I submit my case. May not, my lord, this the award is without jurisdiction of the liquidator, my lord. Only that point I want to advance first, my lord. Thereafter, I will go to that virus of that.
Without jurisdiction, even if this provision is valid,
Even this provision is valid
even then it is without jurisdiction.
without jurisdiction. Only that if your lordship, my lord, if you,
Are you understanding what do you want?
yes,
to
my
submit?
lord, your lordship may
You
ask
want
me
to submit that the order is without jurisdiction.
Yes.
And if your submission is not accepted, then this provision is ultra virus.
Provision itself ultra virus, my lord. Therefore, my lord, then your lordship must, I will submit my lord ultra virus, my lord. Here. My lord, here in the instant case, my lord, the liquidator after the.
Please forget liquidator.
Yes.
Please forget the facts of the case.
Yes.
Come to this provision and tell us how is this
My
provision
lord,
ultra virus.
that ultra virus, my lord, the provision says.
Difficult to make you understand.
Yes, my lord, I understood, my lord. I understood, my lord. Here the provision is that, my lord, that liquidator will start its own motion, the proceeding, on behalf of the adjudicator, my lord.
So it violates which provision?
It is that if somebody is the, my lord, he is the prosecutor, he cannot be the judge of his own cause, my lord. On the basis of this procedure provision, my lord, the liquidator has initiated the proceeding and has advocated the matter. Lordship, again, I am placing that provision, my lord.
So if there is power of review vested where he can suo moto take up,
yes, my lord,
exercise that power, then he becomes the judge of his own cause. Therefore, all the powers of review are unconstitutional. Revision, sorry. Or revision.
My lord,
where there is power of revision suo moto,
yes,
and an authority exercises that power suo moto, then because that suo moto power is there, and he becomes judge of his own cause.
Own cause.
This is your submission.
Yes, my lord. Yes,
Please,
yes.
please.
My lord, your lordship kindly see. This is regarding the dispute concerning to the management, business and constitution of the society, my lord. If society is liquidated, my lord, then the power that after the cut-off date, my lord, that is cut-off date is.
Mr. Your submission is atrocious. If this is your submission, that because the liquidator can initiate and therefore he cannot decide.
Cannot adjudicate that matter, my lord.
Very difficult. If your submission is accepted, then all revisional powers in the country, where the authorities have power to revise an order suo moto, all such provisions will have to be held ultra virus. All right. This brilliant argument has never been made in any of the cases, such cases.
My lord, so much of power has been vested to initiate the proceeding, my lord, regarding the constitution, management and business of the society, my lord, after liquidation, my lord.
All right, forget that. Now come to merits.
Merit, my lord.
115. Sorry, don't press that. Otherwise,
create such time, sir. And for the opening number one.
And if that is the ground, then
no other, my lord, on merit.
Ridiculous.
On merit, I can have.
Yes, what do you want?
I am submitting on behalf of Mr. Ramakanta Naik, opinion number one, council. He is sick, sir. I want time, sir.
So you should have stated before. Requested on behalf of the number one. Let's just matter on 1 day. Yes.
Item 40.
May I please, Your Lordship? My Lord, the petitioner in this petition challenges the illegal seizure of the industrial unit under section 29 and seizure and taking over possession of the mortgage property and by the annexure 2 and taking decision to sell it by negotiation by the annexure 9 and ultimately by selling the same by 2 registered seller. I challenge these 2 documents, my lord. The lordship may kindly see the unit was an ice factory. By the annexure 2 on 23rd 10 2002, the corporation.
Who are the purchasers?
3 and 4 are the purchasers.
So someone is appearing.
Yes, they have appeared, file counter. Reading, sir.
He was directed to file an affidavit on 27/7/2023.
But that affidavit is whether the property is mortgaged or not. But in the seizure list, it is clearly mentioned that it is mortgaged. And
Therefore, it is mortgaged.
My lord.
Because it is mentioned in the seizure list, therefore it is mortgaged.
No, my lord. Because documents are with them. They are not giving the document, copy of the documents, even on Right to Information Act. And furthermore, while issuing notice, notice has been issued to the mortgager also.
You'll have to establish that you are a mortgagee.
Who is the mortgager?
Otherwise, how can you?
Well, I will satisfy your lordship on that point.
No question
my
of
lord.
satisfying. Which order? Which order is that?
LDD has been challenged.
That is, my lord, 27/7/2023 order. That is order number 21, where it is directed that nothing to produce relevant document.
It is admitted case, ma'am, but I cannot produce that because
Nothing is admitted.
Well, I will show your lordship. Annexure 3, my lord, your lordship, okay? Kindly see page 21. Bottom, my lord. Page 21, annexure 3, bottom, my lord.
Just a minute.
Notice to the mortgager.
Mr. Counsel,
my lord.
Will you please allow us to read?
Sorry, my lord, sorry now.
Please wait for a while.
I thought your lordship, my lord.
Please wait.
My lord, sorry.
Where have you said that it is a mortgaged property in your writ petition?
My lord. Lord, in the petition, in fact, in detail, it is not stated that it is mortgaged.
Have you stated a single sentence in your writ petition? And how? All right. So your entire case is based on your claim that it is a mortgage property.
No, my lord, I am challenging on 2 counts. The sale is completely vitiated. And
who are you to challenge?
My lord, my lord, I am the unit holder, my lord.
Unit?
Yes, my lord.
Unit of?
Gala Ice Factory, my lord. I am the petitioner whose ice factory has been sold.
So
and on seizure after it is sold.
you had taken the loan to establish the ice factory.
And fact remains there was a default. Accordingly, they seized it and took possession under section 29. Your lordship may kindly see, I will only show your lordship certain documents, how the sale is vitiated. My lord, by the annexure
sale of what?
Sale of the lands.
Sale of
and the assets, my lord. Assets have not been sold at all.
There are 2 aspects.
My lord.
Assets and land.
My lord.
So you cannot have any claim over the land. Because the land was neither owned by you nor mortgaged.
My lord, it is not their case, my lord. Sorry, my lord. It is not their case that the land does not belong to me.
Is it your case that the land belongs to you?
But in the writ petition, as per the writ petition, though the land does not belong to me, it is belong to my mother. Now mother is dead. during pendency of the writ petition, mother is dead. And notice was
Very
also,
good, very good, very good. That land belongs to mother.
my lord, and she was the mortgager.
She was the mortgager.
My lord.
Where is that?
My lord, save and accept the notice, nothing is with me.
Save
my
and
lord.
accept the notice. So forget that.
It is a transfer brief, my lord, that's why I have no record with me, my lord.
Therefore,
But
be
fact remains,
fair.
my lord, only I will satisfy your lordship, the sale is completely vitiated. Your lordship, only two documents I will show your lordship. First of all,
All right, all right. Whether you have complied with this order or not,
my lord, that is
27th,
not available with me. My best efforts, I could not
we
find
are
it out.
dismissing your writ petition on that ground. The petitioner was
Sorry, my lord, but
directed to, by an order dated 27/7/2023, the petitioner was given an opportunity to produce a relevant document to satisfy this court that LOT Roman 2 comma, which is LOT means
Lot number 2, my lord.
lot is a mortgaged property. So the said order has not been complied with till date. So thereafter, several adjournments were taken on the one ground or the other. Stop. In such view of the matter, we are not inclined to entertain this writ petition, which is accordingly dismissed.
My lord, lot number 1 is there. So far, lot number 1 is there, that is not mortgaged. So in that, I have a case, my lord. Lot number 2, if that goes my lot 2 properties, lot number 1 and lot number 2. Lot number 2 was, but lot number 1 is not mortgaged. There the unit was there. And that has been sold.
Also, which I
My lord.
14.
just
My lord, only I will show your lordship only 2 documents. Nothing more, my lord. So far, lot number 1 is concerned. Your lordship may kindly see page 2031, my lord.
just yes. Where is the impugned order?
Well, impugned order, I am challenging is sale and negotiation, decision to sell it on negotiation. Annexure 9, my lord. My lord, Annexure 9, first one is with regard to lot number 2, I will not press that. Then 31 is about lot number 1, over which the unit was there. Page 31, my lord. It was decided to sell on a negotiation at rupees 12,25,000. 12,65,000, my lord. Now, your lordship may kindly see, sorry, my lord, 12,25,000.
You are at page 31.
31, my lord.
Same petitioner.
My lord.
Petitioners. Also, this is one petition.
Lot number 1, my lord. But though it was decided on a negotiation to sell it on 12,20,000, my lord, but it has been sold on 6,08,000. I want to show your lordship the sell deed. Your sell deed, my lord, Annexure 14, my lord. Your lordship may kindly turn to page 126. The sell deed. The very said lot number 1 has been sold
What is lot number 1?
Lot number 1 measures AC 0.507 decimal total. Just more than half acre.
Annexure?
Annexure 14, my lord. Page 126 of the brief, my lord.
Page 26.
My lord, 126. The Lords may kindly turn to relevant page 135. The sale deed has been, it is sold at rupees 6,08,500 only. Though negotiation was 12,25,000. And there is no valuation, my lord. Before sale, there is no valuation. Only once public notice was issued for inviting tender, and on that very date, on negotiation, it has been sold. And the assets are not sold at all. And when this honorable court directed, when you have sold, to whom it is sold and where it is, and the valuation, it is said that we have sold it to a kabadiwala at 15,000. I will show in the seizure list what assets were seized. That they have not sold, nor it is there. And when the negotiation was fixed was 12,25,000, but it is sold at 6,08,000. It is completely a fraud, my lord, by the authority.
No, what is your right?
And I am the owner of the property, my lord. Lot number 1.
Owner of the land.
Yes.
OSFC?
My lord, OSFC.
OSFC?
My lord.
Yes.
My lord, it was, the sale was affected, my lord. My lord, the possession was handed over.
The amount.
Yes, my lord.
Use that big thing if
Yes, my lord. My lord, I'll. My lord, first, my lord, page 21 is the sale notice, my lord. Page 21 is the sale notice.
No, but what about this page 31?
31. My lord, in my read, they have not given the 31 page. Find out.
use the High Court's
Right.
monitor the
The counter, my lord. Page 21 is the sale notice, my lord. In our counter affidavit, my lord. After that, we have given the.
Mister, please, before that, come
My-
to page 31 of the written petition.
Yes.
This is dated 24/3/2008.
31, my lord. Yes, my lord. This is, my lord, with regard to the sale of industrial assets. Lot 1, that is measuring 0.507 decimal, building and plant and machinery of glass ice factory and cold storage, my lord. You have submitted an offer in BLDC meeting of OSFC held on 19/3/2008 to purchase the industrial assets of the above unit taken under section 29 at a consideration amount of 12 lakhs only, inclusive of money of 60,000. The negotiation on the sale deed and land, building and plant of machinery above was held with you on 19/3/2008, wherein you revised the offer to 12 lakhs 25,000 only, an outright purchase basis, which is inclusive of the earnest money of security deposit of 3 lakhs 6,000 to purchase the asset of the captioned unit as in where
All right,
basis.
so you have understood the amount. You
My
have seen
lord.
the amount.
My lord.
Now show me the sale deed.
My lord.
Where is that?
Okay, 13.
My lord.
Page, page 246.
There are two properties, my lord. One is lot 1 property and is lot 2 property, my lord. This is with regard to lot 1 property, my lord. Who paste sir? Sir, my lord, I don't have that sale deed who paste the quoting.
Annexure 13
Yes, my lord.
attached to the rejoinder.
13, yes, my lord.
Annexure 14.
14.
It's showing annexure 14,
14. There are two sale deeds. Okay, annexure 14.
25.
Yes. Kalpana म्हणतात, all right.
And this has been done, my lord, during pendency of the writ petition. Writ petition was filed on 2/4/2008.
Was
And
there
the
any-
order was passed on 8/4/2008.
Let me ask you to speak.
My lord, sir.
Let him complete.
Yes, ma'am. Whereas here, my lord, the BLD's meeting was held on 19/3/2008 after the proclamation in the newspaper, my lord.
Annexure 14?
Yes, ma'am.
Running page 135.
Yes, ma'am. That running page I don't have, my lord. That's the reason, my lord. See.
Okay. Internal
Sorry.
page 34
34.
of the rejoinder. Annexure 14.
Yes, my lord. Annexure 14 I have got, my lord.
Yes.
Yes, my lord. Here, my lord, at page 97, 180.
Yes, 97
97.
is the amount mentioned. 6
Yes, my
lakhs,
lord. It is 6
8,000.
lakhs for the scheduled land and depleted building and corporation by virtue of a
Not
legal.
dilapidated.
Dilapidated, sorry. And the corporation by virtue of a legal provision of state financial law authorized to effect the sale in favor of the purchaser by execution of the transfer deed,
So why was that sold on that amount?
my lord. It is the transfer deed, my lord, annexure 14.
Annexure 14 is a transferred brief. It's a sale deed.
It is a transfer. No, it is a transfer. Annexure 14 is a transfer, page 25, my lord.
Do you see what was the negotiated price?
Negotiated price was 12 lakhs as per the sell notice. my
And it
lord.
was sold for how much?
Yes, my
For how
lord.
much?
My lord, here, my lord, what I found is annexure 4, annexure 14, that is certified copy 24th August 2021. This is, my lord, a transfer deed. It has been written. The transfer deed, the deed of transfer made on 7th date of April 2008 between Odisha State Financial Corporation, established for having the head office in case Thereafter, my lord, I want to find out whether it is lot number, that particular lot number or not, my lord. This is with regard to lot number 1, my lord. That was sold for 12 lakhs, my lord. That was lot number 1 that was sold,
Yes, we have understood. That's why we are asking.
my lord. This is with regard to lot number 1 or not, my lord, I have to find out.
Find out from the
Yes, my lord.
behind the land details will be there.
Yes, my lord, land details will be there.
From that you
The
compare it.
problem is what has happened, my lord, meantime, that it was transferred to that party, my lord, Kalpana, and thereafter it has again been sold.
And
So
that is different.
Yes,
Initially, who sold it? Who's the
Yes, my
officer who
OSFC sold it.
6 lakhs?
OSFC sold it, my lord.
Yes.
Now, now when it is written here 6 lakhs 80,000, my lord, it is differing from 12 lakhs, my lord.
Exactly.
Yes, my lord. So now, my lord, whether it is with regard to lot number 1, lot number 1 is, my lord, that is the sale of industrial measuring 0.507 decimal building and plant. Building and plant and machinery of the unit of large glass ice factory. My lord, I have to find out whether it is only with regard to the plant.
Page 3 of the rejoinder.
My
That as regards lot number 1,
My
it is humbly paragraph 5 of the rejoinder. So details are given.
Given, my lord.
Yes.
Let me find.
I think you have taken instructions on that.
My lord, that instruction with regard to this sold it, my lord, why it is differing with regard to lot number 1, let me take instruction with regard to that, my lord. Because it's
When was
such a
this
time
rejoinder
has passed, my lord. So why this sold it was registered and
Rejoinder is filed since 2020.
my lord, my lord. Thereafter, my lord, because there is a difference between this price and the sale price, my lord. Definitely, it's a difference of 6 lakhs.
That is
So,
what we're asking you.
yes, my lord. Yes, my lord. I bow down, my lord. Let me take some instruction on this, my lord. I only beg, my lord, a week's time or a 10 days time.
I think you've given an affidavit.
My lord, that affidavit is with regard to the whether lot number 1 and 2 are industrial assets or not. That affidavit was given. Let me take instruction with that.
It will entertain the petitioner's claim. He extended it to lot number 2 of the property.
Lot number 2.
Lot number
you
one.
have
Lot number 1.
Oh, you. Both are same.
No. Sorry.
Lot 2 and lot 1.
This one is Aurobindo, so that is
No, no.
1,65,000.
See the name.
This is Aurobindo by Sanjay Kumar Mahapatra.
Sanjay Kumar, and then here is Kalpana Mama.
Page 31. So maybe same family. But
Well, again. One Kalpana Mahapatra at 12 lakh 25,000, comma, the 1,000 after an auction notice, comma, the petitioner's land and the property thereon have been sold for a sum of rupees 6 lakh.
08,500.
Huh?
6 lakhs 8,500.
6 lakh 8,500. 3 lakh was already given.
My lord?
3 lakh 6,000.
No.
Offer letter is written. You given this balance 9 lakhs 18 you have to give.
So stop. and counsel appearing on behalf of the OSFC seeks adjournment to obtain instructions in this regard. So, as requested, let this matter on 1 week.
My
Lord, may I pray, my lord? OP number 4 is the purchaser. The original deed is with him. Transfer deed. Let her produce, my lord. Lords, and direct OP number 4.
It has been for petition. OP number 4 has purchased this land first from the petitioner, but without any execution of deed. Then, since he did not execute the deed, then, my lord, on auction is purchased and they sold away 90% of the land. And so far the properties are concerned.
So you purchased without any sale deed?
No. Purchase.
You had, according to you, you had purchased from the petitioner.
Purchase means, my lord, I have paid the amount, but sale deed has not been executed.
This is what you said, that you purchased without any sale
Purchase
deed.
means without sale deed. Now, so I paid the amount, then did not execute the sale deed. Then I purchased the land from the OSFC on auction. Then, my lord, I have already sold away 80.
So when you purchase it on auction, it is for that price, which negotiation it was held for 12 lakhs 25. So that is the price.
I'll take instruction, my lord, in this regard. I'll take instruction.
Till date, you have not taken instructions. What is the price paid by you for the land?
The price was not the dispute. And now number of people are there on the constructed the house and
That may be.
yes, my lord.
Dependence purchaser.
Yes.
Yes.
Item number 15. Item number 15 will permitted to withdraw money. Memo 5. Item number 16.
Item 16, also I pray for and pass over, Lordship.
So, an old matter, madam,
Lordship, the
as requested on behalf of the petitioner, list this matter on next Thursday.
Item number 17.
Wait, please, Lordship. I am appearing on behalf of Mr. B. Maharana. And let's see, he's on his leg. So kindly this matter be taken up on next week on any date.
May I submit one thing, my lord, if your lordship kindly permit me? This matter has become infectious by flux of time because I am the development authority. I have submitted notice on him on 2 accounts that he has used this particular plot by change of use zone. That means in residential area he is running a commercial plot. Second, he has made constructions on deviations from the approved plan. So in 2 ways, I have served the notice on him for stop work and vacate the premises. Then he went up in appeal. Appeal remanded the matter to development authority. Development authority again found out that yes, he have made deviation from the construction and running commercial use in the residential area. However, my lord, during penance of the writ application, the power of town planning has been transferred from development authority to Raulkela Municipal Corporation from 31st August 2019. I am not readily acquainted, available with me the notifications, but we have got no more the power. So he has gone to appeal. After appeal, it has been remanded. We have passed the order, but we can't implement it because our power of town planning has been transferred to Raulkela Municipal Authority with effect from 31st August 2019.
All right, next week we will see. As requested on behalf of the petitioner, list this matter on next Thursday.
Published. Item 18.
18 Miller. I have challenged the.
My lord, I am opposite pet number 2, my lord. As per my instruction, petition number 2 is dead.
For petition number 1, 3, 5, and 6, substitution petition were
2
filed.
is dead.
All right. For any petitioner can pursue the matter.
My lord.
Without substitution, any of the petitioners can pursue.
But the
Substitution petition has been filed, he says.
Just others. Substitute filed for 1356. In the meanwhile, two died.
Two died,
What
yeah.
about four?
But yeah, my lordship says it if before your lordship today, beloved. So
Because he is responsible because he has more information than.
Absolutely correct. Absolutely correct.
Serious. Yes.
That happened, my lord, this is a consolidation matter.
This is confidential matter.
Consolidation.
Consolidation.
CH and PFL Act. Your lordship has assigned it to
Single bench, my lord.
honorable single judge.
So why it has been listed before 3 weeks?
Since it was previously listed before a division bench, so it has
Let
come
the
before.
matter
your
be placed before appropriate single bench assigned with the roster. Similar must be the case in BSFC, OSFC.
OSFC, no, OSFC.
No, this is not
OSFC
We know that. They're just asking what is the assignment. OSFC is division bench.
Yeah, OSFC division bench, because the financial institution on that category it comes under division.
Item 19.
Thank you, sir. So, my lord, I am on behalf of Mr. Devasis Nanda. My lord, on the last occasion, this honorable court directed to issue notice to the opposite part number 4, 7, 9 and 10. And the noting is that open over time 9 with the postal endorsement insufficient address and 80 of such notice not received from open number 7 to 10. My lord, I may be permitted to take any substituted service of notice. My lord, this is a matter challenging the order of the member board of revenue.
On which point? This will also go before the single bench?
No, my lord, this is a division bench matter. State OEA Act.
OEA Act.
My lord.
Which is the order under challenge?
On the last order, my lord, order number 8, 4th September 2023, my lord.
No, which order is under challenge?
Annexure.
Annexure 9, my lord.
Yes, what is the legality in the order?
My lord, the illegalities of the order that are the case was instituted from the petition on the strength of the petition under Annexure 3, my lord.
Yes,
my lord. I may apology. Annexure 6, page 26, 24 to 26.
No, what is wrong in the order?
My lord, the application was filed by the collector, the then collector, in the year 2004
Yes.
under the OEA Act. But the matter was disposed of under the OSS Act. Matter was heard under the Odisha Survey and Settlement Act. My lord, then the petition which was referred by the collector. Yes, the petition itself is a defective one.
There the order of a Tahsildar
My lord.
has been set aside by the Board of Revenue.
Yes, my lord.
Board of Revenue had the jurisdiction.
Yes, my lord.
And what else? On what other ground you are challenging the order?
My lord, the ground is that, my lord, the lordship may kindly see the order, the provision under the OEA Act, section 38.
Yes.
B.
Yes.
I may be permitted to submit the
Yes.
Clause 1.
Yes.
The Board of Revenue may, on its own motion or on a report from the collector, call for and examine the record of any proceeding in which any authority subordinate to this Board of Revenue has made any decision or passed an order under this Act, not being a decision against which an appeal has been preferred to the High Court or the District Judge under subsection under Section 22 for the purpose of satisfying itself as to the regularity of such proceeding or the correctness, legality, or propriety of such decision or order, and if any case it appears to the Board of Revenue that any such decision or order ought to be modified, annulled, reversed, or remitted, it may pass order accordingly. 2. The Board of Revenue shall not, my lord, what I am placing is clause 2, revise any decision or order under this section without giving the parties concerned an opportunity of being heard in this matter. My lord, in this
you
order,
were not heard.
My lord,
You were not heard.
my lord, I was heard, my lord, but it's the peculiar thing happened in this order, my lord. Your lordship may kindly see the page number 35, running page 35 of the impugned order, page number 3.
Yes.
My lord, the last paragraph number 2, last line. I may be permitted to just highlight the point on the order, my lord. The remaining part of the suit land seems to continue to be recorded in favor of the Aditya Kumar Ponda. My lord, this Aditya Kumar Ponda is one of the purchaser from my vendor. I am a subsequent purchaser from whom the Hatapata was issued to the then intermediary. Paragraph 3, my lord. Collector Khodda has cited deceased Rajnikant Sahu and the present opposite party number 7, 8, 9 only as the opposite parties in this case. It is not clear in this case as to why did he not cite Aditya Kumar Ponda as the opposite party, and why did he cite the present opposite party number 8, 9 and 8 and 9 as the opposite parties. My lord, this aspect was not clarified in the entire order sheet, my lord. Subsequent, then, my lord, the order was initiated after a lapse of 24 years. My
Therefore,
lord.
while criticizing the order of the Tahsildar, the member Board of Revenue made these observations.
Yes, my lord.
That it is not clear. So he was not required to answer that. He says that it is not clear from the order, therefore the order is not sustainable.
My lord, one piece of land. My lord, one piece of land was purchased by several persons, and I am one of the subsequent purchasers. One portion of the land against whom the present proceeding was instituted, and another portion of the land against which there is no proceeding was initiated. But the entire order was, where the entire order of the deed and Tahsildar was challenged, I was heard, but my land, whether there is a my residential building was existing over the suitable land, that was not taken into consideration.
You could have filed a suit, it's a question of title.
My lord, the illegality in the order was that I was not noticed initially. From the year 2004, when the proceeding was initiated, I was not noticed.
So
The
you are
drum
not
was
making that submission.
drum was beaten. My lord, where drum was beaten in
No, no,
the
you have said initially you were not noticed, but
My
before
lord.
the order was passed, were you heard or not?
Yes, my lord.
So that is the requirement.
Before the order, I was heard, but I am the sole opposite party who was heard. Or none of the opposite party from whom I have purchased the property, from whom the original title flows, they were not.
No, they were not required to be heard.
My lord.
You were the best person. Therefore, you were there.
Since they have sold to you, they will not be aggrieved if anything
My lord,
happens.
some portion of the land, my lord, some portion of the land that's still remaining in the
See, these are such,
different
these are
persons'
such-
possession.
See, the ROR has no, that will not
Yes, madam.
determine your title.
My lord.
So you could have filed a suit to have any dispute.
My lord, I may be permitted, my lord, they may be noticed again through a
No, it is not required. It is not required.
Or notice has returned from OP 9, 7 and 10.
Yes, my lord.
In fact, see, this writ petition was filed in 2011.
Yes, my lord.
We are in 2024.
My lord.
In the meanwhile, your suit would have been decided.
My lord, my lord, here in this case, what happened, my
And
lord?
in no case, what purpose will it serve? In no case, we are going to decide your title.
My lord, I am not on the title, my lord. My ROR was decided on the basis of the OEA Act, and OEA Act diverse the filing of the suit, my lord. When under the any order has been decided on the OEA Act, I am under the bar to file a suit against the government or the parties.
So this order was passed under OEA.
My lord, that is the difficulty, my lord. My lord, the order set, the cause title of the order, my lord, says that the order has been a case was taken up under the OSS Act, but the matter was
So we can clarify that.
my lord, it is the member board of revenue.
So we can clarify if you show us the order of the Tehsildar and the provision under which the said order was passed, we can clarify that this order cannot be treated to be an order under the provisions of OEA Act.
My lord, there are other illegalities and irregularities. My lord, the present proceeding, which was initiated by the collector, that is after a lapse of 24 years. My lord, there is a judgment of this honorable court that though there is no prescribed period of limitation is there, but a reasonable opportunity, a reasonable time frame has to be taken into consideration before initiating such a proceeding, which takes a heavy cost on the aggrieved person. My lord, I have the decision, my lord.
See, you have already made him suffer for so many years.
My lord.
Something which could have been finally decided by the civil court is unnecessarily pending in the High Court.
No, my lord, there is a bar under section. Section 39, my lord.
Right. So what is the bar 39?
Bar to jurisdiction of civil court in certain matters, my lord.
Read it.
What are the matters?
no suit shall be brought in any civil court in respect of any entry in or omission from a compensation assignment roll or in respect of
Compensation
any order,
assessment role.
my lord, or any order passed under chapter 2 or 4 or concerning any matter which is
Not 2 or 4, 2, 2, 6.
my apologies. Chapter 2 and 6
Two.
or
Chapter 2, 2, 6.
2 to 6, my lord. Or concerning any matter which is or has already been subject to any application made or proceeding taken under the side chapters.
We said chapter, it has become side.
My lord.
This is not an order under OEA.
But the proceeding was taken up under the OEA Act, my lord.
Where is OE mentioned
My lord.
in the order?
My lord, the Board of Revenue, Odisha, then OEA RC number 10 of...
mentioned.
Yes, my lord.
The body of the order, whether Odisha Abolition, State Abolition Act is mentioned.
Yes, my lord, that has not been mentioned, my lord. That is the illegality. That is the illegality that I am pointing
We
out.
shall clarify that this order shall not be treated to be an order passed under the provisions of OEA Act. Huh? And therefore, this is what it's saying. Because it was. We'll clarify that.
My lord, both of the act are two separate procedures.
Therefore, we are saying procedure C, whether the order of the Tahsildar could be examined by the Board of Revenue or not.
Yes, my lord, but on the different provisions, my lord.
Exactly, you are right.
Yes, my lord.
The only provision doesn't matter. It's question of power.
My lord, the power is different, my lord. In the OE Act, the power is different, and under the OSS Act, the power is different.
What is the difference?
My lord, the revisional power lies with the Board of Revenue under section 15
of
the OSS Act, Odisha Survey and
This is what
Settlement.
he has done.
My lord, the proceeding was initially initiated under the provisions contained under the Odisha State Abolition Act, my lord. The Odisha State
Therefore,
Abolition
we are
Act.
saying that the order which has been passed shall not be treated to be an order passed under the provisions of Odisha State Abolition Act, rather under the provisions of OSS Act.
My lord, what my submission is that such a proceeding should not have been initiated. My lord, because the since this is a matter which has I am the subsequent purchaser. I have a registered sale deeds. I have BD approved plan, and under the approved plan, I have paid the dues to the government.
We cannot go into those aspects.
My lord, that aspect cannot be governed under the neither under the OSS Act nor under the OE Act, my lord. That is why the illegality.
Should we declare your title?
My lord?
Should we declare your title? Can we do that?
My lord, it is not about the declaration of the title, my lord. My lord, it is all about the whether the proceeding was initiated in the year 1989 by the Tahsildar, where the Hattabota was granted in favor of the person who said to be who claimed himself to be the Hattabotadar of the ex-intermediaries, and from whom subsequently different he sold different portion of the land to different persons.
So
And
you
all
appear
the
to be
persons
right
were not
that-
all the persons.
You appear to be right that you cannot file and we should decide it. We'll
Right.
decide. You're right. Take your seat. Who is for the other side?
Yes, because the private parties are also there. The order of the Board of Revenue is under challenge. We have to also give a reply to that, State has to give a
So you
reply.
have not filed affidavit.
No, I don't know, because my
original,
File or affidavit?
yes, original file was missing, so I reconstructed a file.
Take,
I will collect my friend
I'll-
and get it done now.
Twenty-six, the list to submit.
This is not OEA. Is there any reference to OEA?
So, in the annex 9, there is. Thereafter, finally, there is service.
Yes, what is the provision?
Yes, in fact, what has happened in this case, the land was recorded in the year 70 settlement in favor of the state government mills under Anabadi Khata mills. Anabadi means it's mills, Anabadi Khata mills. In 1881, the vendor of these mills, present petitioners, he filed an application under section 8(1) of the mills OA to settle the land on his favor because it stated that he had paid rent to the ex-intermediary from 1944 to 53. And the Tahsildar notes made an observation that the rent receipt seems to be genuine and they are in possession. Accordingly, notes under section 8(1), he made a declaration that they are entitled for notes settlement of the land, and direction was issued for correction of record of right. Record of right was not subsequently corrected. And accordingly, the notes finding that the collector notes made a reference to the Board of Revenue as per the Act for correction because they said that the observation made by the Tahsildar is without jurisdiction and no procedure has not been followed. While settling the limits, deciding this matter under the OA Act, because reference was under the OA Act, the member Board of Revenue observed that it cannot be one case under section OA Act because it has to be dealt because there has been direction for correction record of right, which has been made pursuant to the settlement operation, and the Tahsildar has got no right to make the correction record of right. That lies with the member Board of Revenue only after the final settlement is over and the ROR has been published. On that basis, he has directed to delete the name of the private tenants from the record of right, and you are directed to be recorded in the name of General Administration Department of Government of Odisha. That is the case.
File your affidavit.
Yes, no. I will collect
My lord, I will
from a
cause
friend.
the
I will file within 2 seconds. File it.
Your writ petition was dismissed. Your writ petition was earlier dismissed for default.
Yes, my lord. Then
And
it is-
therefore, these matters are pending.
My lord. My lord, that is due to the fault of my lord, because the name was repeated of my father, and I could not trace the file then. After that,
But is it not necessary to hear OP 7, 10, and 9?
my lord, they are the vendor of my. I am a vendor
You
of
have
the petition. They have sold the properties to me.
No, they have sold or you have sold to them?
He is
I
the
am-
purchaser.
I am the purchaser and I am in possession of the property till now, my lord.
So you are the right person to be heard. You are the aggrieved person.
Yes, my lord, I am
You will be
the
affected, all right. He has taken their documents from them.
No, 1 and 479.
No. State council appears for 1 and 2.
That should be taken for the service of notice of law. Opposite party numbers 7, 9, and 10. The requisites 1B. 6B. These matters will never be decided. I don't know what advantage do you have by keeping the matter pending here.
Item number 20.
Because you have interim order in your favor.
My lord, that interim order may be extended.
This is why. Therefore, this matter is pending since 2011.
My lord, the
We will not allow.
my lord, the petitioner will be distressed.
No,
petition, my lord.
We will hear you. We will hear
We will
you.
hear it.
My lord, all
Not necessary to hear them.
yes, my lord.
We will hear you. That
Order shall continue in the meanwhile. Let counter affidavit be filed on behalf of copy numbers 1 and 2 positively, failing which the court will consider imposing cost.
what about your wakalatnama? Or you will again miss the case?
No, my lord, I will file the wakalatnama, my lord. My lord, interim order may kindly.
Yes, yes.
continue. Obliged.
Item 20.
I may be pardoned, my lord. After last chance, 2 weeks time may kindly be given because I am hearing.
As requested on behalf of the
Respondent, well, I am from the
Opposite party, opposite party.
opposite party number.
1.
Opposite party, only one.
We'll discuss. We
21.
On behalf of Mr. Mahapatra, my lord, matter may be taken up next week, my lord.
next week.
My lord. Obliged.
Item 23.
File the affidavit within that time. Because some affidavit not filed by BMC. You are supposed to file the affidavit.
They have already filed, your lordship.
BMC, you are for BMC.
No, your private application number 5.
Affidavit
BMC
not received from BMC is the noting.
That is the wrong noting, your lordship. They already filed the reply to that.
See, we are making it clear that these are old matters. And with lot of difficulties, the matters have been listed. No further adjournment shall be granted because these matters have been taken up for the first time after long. Therefore, we are slightly liberal.
My lord, in the year 2024, January itself, we have filed the rejoinder, my lord, after receiving the counter.
We will see that.
My lord.
And we are suffering the interim order.
I am for the BMC, my lord.
Yes.
Item number 23.
Good.
Your lordship, on behalf of Mr. Ramakanta Mahanti, no instruction, your lordship.
No instruction.
Item 24.
Yeah, please, your lordship. The impugned order herein has been passed without noticing or hearing the affected party matters. The facts are like this, matters. In 19.
Where is the order?
The impugned order is at Annexure 6. Annexure 6 at page 62. Sorry? Annexure 8. Sorry, madam. Annexure 8 at page 62. If your lordship takes at page 63, madam, the paragraph beginning Tahsildar Kujang. As your lordship got it.
Yes.
Tahsildar Kujang was duly noticed to appear on 21/2001, but he was absent at the date fixed for hearing.
Where are you reading?
I'm reading the paragraph beginning Tahsildar Kujang at page 63.
Next page.
Yes.
Tahsildar Kujang was duly noticed to appear on 21/2001, but he was absent on the day fixed for hearing. He was also intimated by camp letter number so-and-so and letter number so-and-so for giving his views regarding the claim of the petitioner. Petitioner Mallows is opposite party number 6 here. RI so-and-so present on so-and-so was directed to produce relevant records and views of the Tahsildar on 2011-2001. But they neither appeared nor gave any information. Hence, the order is ex parte on the opposite party. Thereafter, my lords, on the next page, page 64. The law is well settled that a person who immediately before the date of vesting of an estate was in possession of any holding as a tenant or intermediary shall on and from the date of vesting be deemed to be a tenant of the state government. As such person shall hold the land in the same right as he shall continue as tenant under the state under section 8(1) of the OE Act. Peruse the report of the Amin, which reveals that the petitioner is in possession of the suit land. A separate plot has been created as per consolidation possession of the petitioner. And then the last paragraph, in the above premises available evidence on record, the court is inclined to record the suit plot number so and so in favor of the petitioner and Stitivan status. This order is passed on 18/1/2003. Now, much before that, this land was requisitioned by the IDCO, that is the petitioner, for the setting up of the Indian oil refinery at Paradip. In 1998.
Requisition.
Requisition for acquisition.
From?
From the state government.
Yes.
And in 2000, a deed was executed by the state government in favor of IDCO, leasing out this property along with other lands to IDCO. And IDCO has thereafter leased out the property in question in favor of IOCL, where they have set up a refinery.
When?
The refinery has been set up in post 2005.
But after 2000.
No, the lease was, the possession was handed over in 2000. 2000. So, my lords, in any event, the recording of by the Amin saying that the land was in the custody of the petitioner is on the face of it erroneous.
So
and my lords, IDCO was neither a party to this proceeding, nor was IOCL a party to this proceeding. They were never noticed, and the state government was noticed. State government also did not appear. So I pray this order, which has been passed, prejudicial to the interest of.
No, but that has been passed by whom?
It has been passed by the commissioner. Sorry, by
Tahsildar or something.
Consolidation officer of Kujang Malabs.
But you have remedy under that provision.
I don't have a remedy because I was not a party there. I was not a party there.
Oh, consideration and there. Anyone can question. This order was passed under which provision?
Perpetually under section 37(1) of the OCL and PFL Act. Against
remand
37(1).
37(1).
Remand.
Revision case.
No, it was remanded under section 37(1). Thereafter, it has been heard. Remand filed under section. Second paragraph. Revision case number so and so filed under section 37(1) has been remanded to this to the CO for disposal.
This was remanded.
After the remand. The impugn order is after the remand by the after impleading the local Tahsildar.
Tahsildar.
That means you were not a party also in that.
No, I was never a party. I was not even aware of this.
So,
I became aware of this in
when
2000.
that revision under section 37 was taken up, had you bought had the land been set?
Yes, much before that.
Where is that order?
That order, my lords, annexure.
That order is not.
I had made the requisition on 4/8/98.
Revision case is of 98.
98. It was filed on 28/10. That is after. I made the requisition on 4/8/98. The revision case was filed on 28/10/98. After.
But in the revision case, the order is to hear the Tahsildar and pass order.
pass orders, but it was for the state to bring it to the notice that we are no longer in possession of the land. We have parted with the land in favor of IDCO.
So this was remanded by whom?
By the Commissioner Consolidation.
Should we challenge that order or this order?
Both the orders, the remand order also was
Because the remand order says pass order after hearing the Tahsildar.
the Tahsildar should have, the state should have brought it to the notice of the Commissioner Consolidation that we have parted with the land.
The state chose not to appear before the consolidation.
They did not choose to appear.
No. What is who passed this order? Annexure 8.
Annexure 8 has been passed by the Consolidation Officer. On remand by the Commissioner,
has been
the
remanded.
Consolidation Officer has passed this order.
So if any order has been passed by the consolidation officer, you don't have any remedy against the order of the consolidation.
Because I was never a party. This order was not within my knowledge till 2009.
No,
This is what we
Then
want
2010.
Even
This
then,
is
can
what
you
we.
not challenge? If you are agreed by that order,
Any person aggrieved, my lord, I don't think comes within the fold of the Consolidation Act.
consolidation act the less.
You can file 37. 37(1) you could have filed.
After.
If you don't have any remedy, then 37(1) is the remedy. And come to this 36. 36 is remedy. Any person.
The fact of the matter is, this matter has been before your lordship since 2011. Now, my lord, at this stage, if I were to relegate it back.
No question of relegation. The question is of
Alternative remedy. Availability of.
alternative remedy. We understand what you want to say. We were saying that even if there is an alternative remedy, now since the matter has remained pending before this court for 13 years, this court should not relegate. The question is that what is the status of the case as on date?
The status, my lord, he just wants that this person, opposite party number 6, he wants that he should be compensated by the state for the acquisition which has happened.
Particularly when the
Because now land is no longer in existence. It's the refinery. It's a part of the refinery now.
particularly when it is more efficacious. The consolidation authorities, it is their decision.
Your lordship may observe that and dispose of that. I will have a remedy before ye. So this, I will file a revision within the.
An order passed by
I'm going
the.
to object on the 6th.
Are very happy. Passed by the consolidation officer. Under the OCH and FLA or PFL Act 1972 full form. Dated 18/1/2003 has been challenged in the present petition by the Odisha Industrial Infrastructure Development Authority.
Development Corporation. It's a statutory body, madam.
Development Corporation, which is a statutory body. So stop. It is the case of the petitioner that it was a necessary party which was to be heard which ought to have been heard by the consolidation officer as the land in question was requisitioned by it from the state government and subsequently allotted to IOCL or what?
Indian Oil Corporation, yes.
IOCL.
State government leased it to IDCO and IDCO leased it for this granted it.
He has submitted that as the petitioner was not heard, the impugned order suffers from the vice of violation of principles of natural justice. Stop. Next. Be that as it may, the said order has been passed by the there are statutory remedies available under the SID Act, particularly under sections 36
No,
and
this 36 is the revisional director, appeal lies to the director.
37.
37.
no, 37 is
No,
revision.
37 is also the EA power. Revisional power.
Appellate way is the appellate.
But appeal lies director consolidation. That provision.
Director, this is 36.
No, that.
All right.
36 is agreed by the decision of the director of
Director.
consolidation.
So director is the appellate authority. Appeal matter does it that provision.
20. Under section 20. Under section 20, comma 36 and 37 thereof. Full stop. It is true that the petitioner's appeal shall be barred by limitation if it prefers an appeal under section 20 of the Act. So it shall be at liberty to take such plea as may be available to it for condonation of delay, including the plea that it was pursuing
under section
its
14.
remedy before this court by filing the present writ application. First off, in any view of the matter, section 37 does not prescribe any limitation. That doesn't prescribe any limitation.
No, it's a open power.
Prescribe any limitation.
Overriding power of it.
Which can be pressed into service, sorted to by the petitioner if situation such warrants. Stop. With the associate observation, without entering into the merits, rival merits of the case of the parties, this writ application is disposed of with a liberty to the petitioner to avail statutory remedies under the provisions of the Act.
Public.
25.
My lord, I may pardon, my lord, I am appearing for OP number 2 and 4. Lordship, I have received the parawise comment. Your Lordship may give me 2 weeks time to file the counter affidavit, my lord.
2011.
This is 2011 matter.
Lordship, we were noticed in the year only 22, my lord, 2022.
Yes, what is the matter?
Matter regarding employment under Odisha Resettlement and Rehabilitation Policy 2006. I am a land out person. Subsequently, the opposite party acquired all my agricultural land. The policy in the 2000 policy under Annex 3, page 25, I am coming under clause P. My land.
2 weeks time is allowed for the which opposite party?
OP number 2 and 4, my lord.
Opposite party number 2 and 4 to file counter affidavit. This is matter on 3 weeks. Stop. The time in the meanwhile may be utilized for run counsel for the petitioner to file rejoinder if so advised.
Lordship, oblige, your Lordship.
Oblige. Item 26. Item number 26.
Yes, Mr. Chakri, you are not well. You are not well. Mr. Chuli. You are not well.
Yes, sir.
Mr. Mohanty is, how old are you?
I am 79.
And you?
I'm 58.
Just think of, you are sleeping in the courtroom. Yes.
Item 26.
There is no representation on behalf of the petitioner. Let's this matter on next Thursday.
Item 27.
Same order.
Item 28.
Same order.
Item number 29.
I know the notings of that. I is not generally inclined. Fortunate situation. I will got transferred to me.
What do you want?
At least for 10 days. I am going through the file in the morning. Very confusing facts.
You for the petitioner or opposite party, Mr. Mohanty?
Petitioner.
What do you want? Should we adjourn it
10 days, 2 weeks.
as requested?
My lord, in this matter, I am for OP 2 and 3, that the municipal corporation. So, matter is lingering only for the identification of land. That is to be located by the state. And the BMC has nothing to do on that.
That is all, Mr. Mohanty, that is all. Only the land has to be located.
And under the Street Vendors Act, I cannot be evicted till they provide me alternative land. That is how this.
But street vendors,
orders by this under code that they will be, I will be given the land. Then they ask this BMC to search. BMC came out and told that no land is available. Then people are, I was given the task to search. Then I expressed my inability when I went from Bhubaneswar, I find out that none of the section 9 was on. I am a street vendor.
a street vendor means you'll have that temporary kind of trolley or whatever. Not that the land has to be Rasta side.
Rasta side.
My lord, these people are located near Rajmahal Square, Bapuji. So, what is the roadside? So, they come up with a writ application, my lord, in 2008 and 9. Then continued in 2011. The lordship, the order was passed in 2021, directing the BMC to locate the land. So we search for the land. Ultimately, the government has to come out providing land so that BMC can take over. So the government now expressing inability in the last order on 3rd of August 2022 that no land is available. Then we are informed that the no land, government land is available in the vicinity of 10 kilometers. So that's the situation.
Well, it is a mandatory requirement on the street vendor side that you have.
But the street vendor issue, my lord, is rising so much. Every 10 years, there are some street vendors. The capital city has grown up in 60, 70 years.
It's not your only. You have not, they have not followed the street vendors right from 2000.
That came in 2020, my lord. That came in 2020.
2014.
2020.
So what will happen if there is no street vendor?
They like they have stand in this case that they will construct a plaza there.
No, it's a roadside. Exactly. The report of the government and the report of the Bhubaneswar Development Authority that the location where these petitioners were running their business is a roadside, and it's a road almost parking place of the road.
No, they have to construct a plaza there.
Mr. Mahapatra, the whole idea of street vendor is they have to be on the roadside only, but
No,
not
madam,
on the road.
No, madam, not on the road. That's not happening. My lord, there is rehabilitation program already. Lots of you have seen.
Yes, they have some.
Visible. So there is no surplus land where these people can be rehabilitated. That's the issue.
Already people before them are occupying those roadsides, right? That is
Madam, and they have already been rehabilitated.
Okay.
Lay down some directive to the state government to enforce this street vendors act.
Lordship, can have a look to the order dated order 19, madam. Order 19.
You suggest that the petitioner should inform the BMC if any land is available. How can they?
Scanning.
How can they identify and tell you that, see, this is the land which can be given?
My lord, my instructions was, and our affidavit we have filed, there is no government land available within the 10 kilometers radius of the place where the petitioners are operating. So now there is no land. And that is the reason state government have filed an affidavit which has been quoted by my lord.
What do you want them to do?
My lord, either the state government to provide the land so that we can provide them the kiosk. Unless until state government provides the land, because the state government is the authority of the land. We don't have any. Corporation did not have any land.
Has no land.
And that is what the state government have filed an affidavit which has been taken record. The order dated 3rd of August. Order number 19, madam. Order number 19. Para number 3, my lord. Para 3.
Yes.
In the present third writ petition, detailed order was passed by this court on 3rd of March 2021, pursuant to which an affidavit has been filed by the opposite party number 1, state, in which it is stated in paragraph 10, 11, 12, and 13 that the additional commissioner BMC in letter number so-and-so, has requested for sanction of land and lot in favor of BMC in respect of the area measuring 1 acre of government land for rehabilitation of the petitioner in compliance to the orders passed by the Honorable High Court in WPC number 4643 of 2008. That suitable government land measuring area of 1 acre is not available in Unit 1, Bapuji Nagar for allotment of alternative land. That the prayer of the petitioner to regularize the allotment process in respect to plot number so-and-so to allot alternative land in the vicinity, the plot number 295 is not suitable at this stage due to the fact that the area has been kept for the development of public plaza under Bhubaneswar Janpath Smart City project. Further, Bhubaneswar Development Authority did not accord possession in favor of the Bhubaneswar Municipal Corporation in respect to the plot number 295 for construction of kiosks, even though the permissive possession was granted in favor of BMC by GA letter numbers dated so-and-so, so-and-so. that on verification of the comprehensive development plan of BDA, it is seen that the plot number 295 and the adjoining plot 294 and 296 are coming in the road zone. Then, my lord, that it is further submitted that suitable land in the vicinity is not available for allotment in favor of the Bhubaneswar Municipal Corporation. Even the Bhubaneswar Municipal Corporation has requested for allotment of measuring 1 acre by letter dated 6132-93-2015 and 1466 dated 75-2015. No specific land schedule has been indicated for consideration. So, my lord, this is the situation. The corporation is in a predicament not to cannot.
Do you have town vending committee?
Nothing. No, we don't have any committee.
No, 2 years back when order had been passed for.
All right, you don't have town vending committee. Just
I have to check out with that because in the meanwhile,
there is no question of check out. This is 2011 writ petition.
No, my lord, there is no question onto that point. So that's why I'll check out.
This is the question. This is the act.
I'll come back.
Am I reading the correct?
I understand this because the situation was, my lord, once the government would be allotting 1 acre of land, then we can rehabilitate.
Forget land. First of all, stick to the act. We need to follow the provision.
No, that's true.
Forget land. Don't do anything about land. Land, the court will give you if you don't have.
That is the state
government does not have. Yes, the state government does not provide the land. The BMC does not provide the land. The court will provide. All right. But the land is secondary. The main question is that you have not followed the law. What can you do? If today 10 acres of land are provided to you, what will you do?
My lord, we will be going for the purpose for which it is allotted.
No, without
How can you do that?
You cannot allot.
You have to have a committee. You have to give certificates to the street vendors under the provisions of the act.
That is why, my lord, we filed an affidavit that the corporation considered in their committee, in the corporation meeting itself, that
Which
no
committee?
land is available.
No. All right. Just we are directing. List this matter on Thursday.
Government will also find out.
On Thursday. Stop. Let two separate affidavits be filed. One on behalf of the Municipal Corporation and the other on behalf of the state government in the Department of Urban Development.
General Administration Department.
General. Stating step-wise the actions taken so far for implementation of the provisions under the Street Vendors Protection of Livelihood and Regulation of Street Vending Act 2014. Stop. We at the outset indicate that for due implementation of the act, the local authority, the state government, the local authority and the local authority have duty to constitute town vending committees under section 22 of the said act. Stop. The section chapter 2 of the said act deals with a regulation of street vending and requires inter alia survey of street vendors and survey of his street vendors, issue of certificate of vending. And the conditions for issue of certificate of vending. Stop. The court would like to know from the corporation and the state government as regards steps taken so far. We are of the definite view that it is the statutory obligation of the authorities under the Act to implement and carry out the provisions of the Act. Yes, first.
Item 31.
Interim order to continue.
Interim order shall continue with the mayor.
29 and 30.
Yes.
29 and 30 was interim order.
29 is what? That is something else.
That I 10 days after your that.
Interim order is there.
Yes.
Item 31, my lord. The matter relates to Sisubon and by the order dated 17/11/2021, the lordship constituted a committee and committee visited the Sisubon twice and filed his report on 14/12/2021 as well as 19/7/2022. And when we visited 14/12/2021, we find some irregularity, and as per your lordship direction, we filed the video clips and as well the photographs of the Sisubon. Then the lordship director again visited for the update. What development has been made in the meanwhile? We again visited on 19/7/2022. Thereafter, we again came to know that very miserable they have developed. Now we are in 2024. 2 years has been passed in the meantime. And another major factor is that while we visited on 17/11/2021,
where is this located, Sister Bhavan?
Near our Honorable High Court.
It's adjacent to the High Court, Honorable High Court.
Sisu Bhavan is hospital.
Yes,
Yes,
yes.
yes.
For
Children's
child
hospital.
Pediatric hospital.
What is your grievance?
That is, your lordship constitute a committee to visit what is the irregularity and what is the requirement of the Sisuban for the better treatment of the kids. Then we visited on 18/11/2021 and we filed our report along with the videographs and photos on 14/12/2021. Thereafter, the lordship directed to look into this report and develop accordingly. And your lordship again directed, we visited and filed our report on 19/7/2022. Thereafter, no development work has been done. And the main thing is that when we visited on 18/11/2021, they assured the committee that by March 2022, the new building will be operated. Now more than 2 years has been passed in the meantime. On their version, they committed the committee constituted by lordship that they will start the operative by March 2022. Now we are on August of 2024. More than 2 years.
This is also a petitioner in this
Yes,
case.
yes.
Only small submission I want to make, though the new building has already been constructed by your lordship interference, but it is not known why that has not been handed over.
Where is the new building?
New building in
Adjusted to
premises, my
that.
lord.
Just adjusted to that hospital.
That's premises, inside the premises.
Same premises, no, same premises.
Already construction has been over, my lord.
But they're
2
not
years,
already
3
handed.
years already passed, but they are not handing over the building. It is very easy thing. Why they are not handing over, that is best known to the state. They can explain.
An affidavit has been filed pursuant to lordship direction, dated 7/8/2023. And in that,
Just a minute.
in that affidavit, your lordship may look at it, I have given, it's humbly submitted that in compliance to the observation number 13 of the Lords Committee, dated 19/7/2022, on fire safety certificate, it is stated that prior to commencement of fire prevention and fire safety rules, the hospital has been running in the old existing building since 1966. adequate firefighting measures like fire extinguisher, fire alarm disturbance system, fire hydrant, down corner system have been installed to meet the onwards incident. The application for fire safety certificate on the new ground plus 6 hospital building will be initiated after obtaining the building plan approval from the development authority, and the process will be completed by 30th of September 2024. So this is not there unless we get that fire safety clearance. We cannot hand it over to the authorities for the running. And again, I've given a detailed affidavit. When we will be operational, everything I've given my affidavit.
Where is that October 24 date? Where is it?
That is at paragraph 5 of my affidavit dated 4th of September 2023.
So 1 year for all that you had asked. 1 year.
Yes, Lord. Now the building is completed.
Yes.
And
Infectious.
This admission item number 33.
Item number 33, we seek a week's time, my lord. The conducting council is unwell today.
As requested 1 week.
Item 34. Item 34 and 35, both are similar matters.
Item 35, about 475 matters, we can see the last matters.
That 35, similar, more than 700 similar matters are pending. They have collected a list of 500 cases and other cases which are yet to be collected, and I'll furnish that data. May I pray your lordship may fix it to any date so that I will give the entire list. Now 500 cases are with me.
What is the issue?
That is regarding that issue, my lord, pension to block grant employees.
So for the teachers and lecturers, teachers in the schools, ME schools, high schools, and the lecturers in class 2 college and degree college. Now question involved is a particular rule, that is 74 rule, whether it is at all made applicable to the grantee who are receiving the block grant. That is the first point. The second point is, there is a rule, that is 81 rule, that pension rule. Whether if the 74 rule be applicable in respect of block grant employee, then 81 rule will automatically come in. So all these cases relates to that 81 rules. The Honorable Single Judge has said that both 74 rule is applicable or 81 rule applicable, as a result of which the block grant employees of throughout the state, both school, college, all will be governed by that. So issue is now, so the large number of cases, Mr. Khutia said that we have already filed, but one case has come where my learned friend is appearing.
So far as school and mass is concerned, at present 500 data 500 is with me.
Already filed, appear has been filed.
Yes, 501. So far as higher education is concerned, also there are 500 to 600 cases are there. So provide that. They will provide me that data by tomorrow. I will also fix it to next. I'll give the data in the next week, and you'll also can fix another.
List this matter on Tuesday.
I'll give the data only first.
Under the heading to be mentioned, along with other writ appeals.
Yes, sir.
Said to be involving the same issue as involved in the present appeal. List of which shall be a list of some of such cases shall be supplied by Mr. Khutia Learned AGA. By tomorrow you can do?
By Monday, I will furnish higher education. I am submitting.
By Monday. So it will come on Wednesday.
Wednesday.
And so far as school and mass is concerned, I have already furnished.
At 2 p.m.
Yes.
So it's made clear that we will not hear that case.
Yes,
that day.
that you also will fix up another
We'll
date.
just fix for the
Yes,
fixing,
yes.
a date.
And the appeals which filed in respect of that school and mass education also direct them to list those
These
matters.
cases shall be listed.
Yes.
Along with
Well, I'll
these cases and other cases, if you in the meanwhile.
Higher education, I'll furnish by Monday, my lord. By tomorrow.
Item 34 and 35.
34 and 35.
Item number 36.
Item number 36. Pursuant to Lords of direction on 11/7/2024, my lord, I had filed an affidavit on 25/7. I find from my record, my lord, that the affidavit does not have those particular material particulars what your lordship actually wanted. So may I be permitted, my lord, to withdraw that affidavit and to file a better affidavit, my lord?
I have an objection. The requirement your lordship wanted, those requirement has been fulfilled by the OPSC. Your lordship wanted only one information. The last candidate who was selected and recommended for appointment, above him, how many candidates secured more marks, but they have not been offered. They have given in a chart.
My lord,
they have given in a chart. Now they want to take it out. Your lordship may kindly have a glance to the chart itself.
All right. See, something which has come to the High Court cannot be returned.
Yes.
So it will be there on record always.
Oblige, your lordship.
So he will not press that affidavit that much, we can say.
Your lordship only wanted that affidavit, and I have secured a mark.
See.
9 candidates securing less mark.
Just a minute. According to you, you have been able to make out a case on the basis of whatever affidavit has been filed.
My lord.
All right. This is what you
That
want.
is the judgment of the Honorable Single Judge also.
Understand?
Right.
He wants that he should be allowed to withdraw that affidavit and file a better affidavit. So he has filed an affidavit that shall be there on record. We are just permitting him to file an affidavit. All right. You can say additional affidavit. The point is very simple, and you are right, that if someone, the last candidate above him, everyone will have to be appointed or others will have to be removed. In accordance with
Whatever the data is required by your lordship's order, those data are available.
So you can compile that. You also can file an affidavit that these are the persons. Don't confine your case to your petitioners only.
No. Your lordship therefore directed on the other day, suppose the last candidate has secured X mark and some other left out who have not been referred to the government for appointment, you just give their details. They have given their details with the marks. There were 198 vacancies. Out of 198 vacancies, they filled up 171 first. Out of 171, I have secured 191.2 marks. And the candidate, those who have secured 184, they have been given appointment.
So how many candidates are there? How many candidates are there who have secured more marks than the lowest person who has been appointed?
According to them, it is 43.
43. So all of them will have to be adjusted.
But below my marks, about 9 candidates from a bad.
Why are you confining, mister? You are an officer of the court. You are representing your client. That is one aspect. But at the same time, you are an officer of the court. So you may plead on their behalf also who are not there before the court.
It's on my submission, your lordship passed that order. On the other day, I submitted that there are large number of candidates who has been left out. Therefore, your lordship directed them to give the details.
All right. What is not there in the affidavit?
Lordship, my lord, except giving those few pages of the annexures, your lordship actually wanted me to state, my lord, Let the OPSC file an affidavit giving the list of candidates who had been recommended and had been appointed to the post advertised.
File an affidavit, 1 week.
That has been supplied, my lord. This requirement has been fulfilled by
1
them.
week time for filing me a better
See,
affidavit.
that will be in your interest also.
No. Yes, sorry,
That will
sorry.
be in your interest. They will be filing an affidavit explaining that this is the circumstance in which these persons could not be recommended. You see, you have a good case. And not only you others also.
Only since
Time.
2015
What
since
will be done?
2015 on the plea. And first they filed an affidavit.
This is a writ
The
appeal of
petitioner is
2024.
unable. Petitioner could not qualify the above the cutoff marks. Then I filed a contempt petition. Contempt petition. The court hold that since they are
When was
already
the order passed by the learned single judge?
learned single judge passed an order. There is an expert committee.
When?
14/12/22.
So it was passed in 24.
No.
My lord, prior to that, there was another round of writ petition.
Maybe, but we have to decide the appeal. No?
Oblige, your lordship.
Giving 1 week time, that will help us also in writing the judgment.
Oblige, your lordship.
1 week further time is allowed for the OPSC to file. By this court, by order dated
11/7/2024.
11/7/24. Is this case on 1 week? Not 1 week. It will come on Tuesday. Not this Tuesday, next Tuesday.
Next week.
Within first 5 cases. All right.
Oblige. Oblige.
37.
Item 37, my lord. Lordship, can it be taken up 2 weeks after, my lord? I pray.
Item 37.
37, my lord. My lord, can it be taken up 2 weeks after, my lord?
2 weeks.
Item 38.
38, your lordship. Need 2 weeks time to file a counter affidavit, your lordship.
But lordship, I have instruction, lordship, the higher authority given direction to the lower authorities, lordship, to execute agreement. But they are not doing my instruction, lordship, because personal lordship direction last occasion in fact, the court's order, lordship, they have given direction for execution agreement. But the OP number 4 is intentional sitting over the matter, lordship.
Where is the direction?
No, direction, lordship, only obtained instruction. On their instruction, lordship, it has been directed, lordship, for execution of agreement.
Who has directed?
The chief engineer, lordship. The chief engineer has given direction for execution agreement, but he is sitting over the. They have already.
See, affidavit will have to be filed.
So short date, lordship, because of
2 weeks.
2 weeks.
As requested on behalf of the state. 2 weeks time is allowed to file the counter affidavit.
Yes.
Item 39.
May I please your lordship? It's a matter in related to construction of the court building, your lordship.
Construction of?
Civil court building.
Where?
At block headquarter Kosagunda, your lordship. In the district of Nambaram. My lord, kindly peruse Annexure 1, your lordship. It is at page 17. This was a notification issued by the opposite party number 1 as per the direction of the Honorable Court to construct and establish some 30 numbers of civil judge unit division in each of the block headquarters, your lordship. Wherein the place I filed this is serial number 20, your lordship. Here, your lordship, soon after issuance of this notification, your lordship, there was a letter issued by the collector to opposite party number 3, the registered civil court of Nabarambur district, to cooperate the Department of the Revenue Department, Your Lordship, to identify the land. Thereafter, as per Annex 3, Your Lordship.
This is Kosamunda.
Kosamunda, Your Lordship. There is already, my Lord, kindly peruse the joint committee report at page 27, Your Lordship.
What do you want? Kosamunda building is complete or not?
Till now, no completed, not is completed, but site selection is there. And
No, but your photographs are there?
Yes, temporarily accommodation is there, Your Lordship. That is not, till now it is not functioned. And some legal aid camp was held there. And this is the demand of the general public of the Kosamunda, Your Lordship. Now the notification issued on dated 5/7/2024, Your Lordship, to changing the place, one place to another, that is Kodinga. That is
difficult. Where is that decision?
in Annexure 9, Your Lordship. Annexure 9 at page
That
29, Your Lordship.
you are challenging this Annexure 9.
This Annexure 9, Your Lordship.
No, cannot be interfered. That is in consultation with the High Court of Orissa.
My Lord. This is the act only.
Huh?
They have stated the Odisha Act 18 up to 1884, Your Lordship. But there was already, as per the scheme, justice to doorsteps, and as per the demand of the local public, this case was directed to establish at Kosamunda, Your Lordship. And my Lord, kindly peruse the last.
And how far is Kosamunda from this place?
My Lord, kindly peruse page number 42, Your Lordship. Page number 42, that is the Google map, Your Lordship. Why this place was selected? Here, Your Lordship.
No question of place. Now it has been notified.
My Lord.
Now it cannot be changed.
Yes, Your Lordship. First notification is already over. Already site selection committee was already selected the place, Your Lordship. Already 3 years.
No, but no construction had started there.
No, my Lord. It's a hinting.
What is wrong? That is with the consultation with the High Court. At Kodinga.
Yes, Kodinga, Your Lordship. That is 45 kilometers away from the Navarampur. That Kodinga, there is no any communication and there is no bus stand also. Only the Tahsil office is there. At Kodinga, there is only the bus stand and Tahsil office is there. But all the communication, all the offices, including the bank facility and the health facility, are at Kosamunda. That is the block headquarters, Your Lordship.
The presented application has been filed in the nature of public interest litigation, seeking a direction that civil court building, which has been, which civil court building?
Name of the court.
Which civil court building?
Civil court building, junior civil court, junior division, JMFC.
Court of Civil Judge, Junior Division at Kodinga.
JMFC at Kosamunda.
Should be established at Kosamunda instead of Kodinga.
The district of Navarampur, Your Lordship.
No. Initially it was Kosamunda. Now it is Kodinga.
Now it is Kodinga.
So your prayer is it should be Kosamunda.
Kosamunda.
So both are in the district of Navarampur.
Navarampur.
Yes.
But the village Kodinga is near the block headquarters of the Papadahandi block. Papadahandi block, that is also far away from the
particular area.
A notification dated 5/7/2024 issued by the government of Odisha and the law department, whereby establishment of Court of Civil Judge Junior Division at Kodinga has been notified in consultation with the High Court, with the High Court of Orissa. Stop. And counsel appearing on behalf of the petitioner has submitted that Kosa Ponmura is more convenient place
21 done.
for the litigants and lawyers than Kodinga. And therefore, the decision to establish said court at Kodinga is not in public interest. So stop. Next, exercising power of judicial review under Article 226 of the Constitution of India, we decline to interfere in the decisions, in such administrative decisions relating to relating to the place of establishment of court as decided by the state government, as notified by the state government in consultation with the High Court. Stop. This application is accordingly dismissed. Yes.
Item 40.
Mr. Item not 40 item, the order has been completed. I filed the compliance affidavit on 22nd of April 2024.
It's my contempt. So let me first go through this.
Yes,
Mr. Counsel, don't do it, please. This is not the way.
Oh, I'm sorry. I'm sorry, my lord.
You can't address him.
I'm sorry, my lord.
Please make your submissions.
Your lordship may kindly see, my lord, how the contempt has been made, my lord. Lordship may kindly come to page number 16.
See that.
Page number 16, my lords.
Yes.
This was the first order which was passed on my read petition, my lords. It is 16 November 2020.
What is the order?
My lord, is para number 4. In view of the above, this court disposes the read petition with an observation that in case the petitioner files a fresh objection before the learned acquisition officer, Sundargarh, opposite party number 2, along with relevant documents within a period of 15 days, in such event, the said opposite parties shall refer the objections of the petitioner to the competent authority as provided under Section 64 of the Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, who shall consider the objection in accordance with law after giving opportunity of hearing to parties. In compliance to the order, my lord, I have filed objections. In compliance to this order, I have filed objections, my lord. They remain silent. Authorities, respondents, they remain silent, my lord.
Which authority?
Collector and land acquisition officer. Then, my lord, second read petition was filed. Page number 26 this is the order.
So there is no violation of this order.
There is no violation, my lord. There is a violation, my lord.
No, because you filed another read application.
I did another read application.
So they have. So far this order is concerned.
They have not complied with this order.
No, you cannot now allege disobedience because you did not file any contempt application for disobedience of this order. So forget this order for the purpose of.
No, I'm not in this order. I'm on the second order. Page number 26.
Order, yes. Page
26.
Yeah.
This was the order passed on 24th February 2023. This is para number 4, my lord, the crucial part.
Just a minute. Yes. So whether representation has been disposed of or not?
No, not disposed of. Till today, not disposed of.
All.
Now to save their skin, my lords, they have referred the matter under Section 64.
All.
Section 64 clearly says it should be on my application to the collector.
All right. So this is your submission.
Please, Vilas.
Yes.
No, he made a representation, and because to resolve the dispute, we report to the appropriate authority for blood dispute. So what is the illegality, my lord?
All right. So where is your
Your compliance affidavit, your lordship may kindly come to page annexer D/2, page 8.
where is the order?
Page 8. The matter was taken up first on 19/12/2023 pursuant to
29/12/2023.
Yes, ma'am. This was first taken up, and ultimately, on 1/1/2024, this was disposed of.
10/1.
Sorry, 10/1, page 9.
The
case is taken up today. Sri Ajay Kumar Kedia remains present, absent,
all right.
and it has been referred to.
All right. The petitioner in the present contempt application has alleged disobedience of this court's order dated 24/2/2023, passed in WPC number 4795 of 2023. The operative portion of which reads as under. Stop. A compliance affidavit has been filed on behalf of the contenders, stating therein that the petitioner's representation has been disposed of long back by the land acquisition officer Sundargarh by an order dated 10/1/2024, whereby after considering his representation, the petitioner's case has been referred to the Court of Land Acquisition, Rehabilitation and Resettlement Authority in accordance with the provision under Section 64 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. When counsel appearing on behalf of the petitioner has submitted that the said order dated 10/1/2024 does not amount to compliance of this court's order whereby the representation was required to be disposed of. So he submits that instead of deciding the petitioner's claim, the land acquisition officer, just to save his skin, referred the matter to the Resettlement Authority, Rehabilitation and Resettlement Authority under Section 64 of the Act, and therefore the contender is liable for initiation of contempt proceeding. Stop. Next. In the court's opinion, with the passing of the order dated 10/1/2024, in the court's opinion, since an order has been passed on 10/1/2024 by the land acquisition officer in terms of the court's order dated so and so, we are not satisfied that any case of willful disobedience of this court's order is made out. So stop. The question of legality or otherwise of the order dated 10/1/2024 cannot be gone into in a proceeding, in a contempt proceeding. So stop. The petitioner shall be at liberty to take recourse to the provisions of law as may be available to him. The contempt proceeding stands stopped.
Item number 41.
Get to.
But item 41, I am there on line today because I am little bit.
41 minutes, the lordships. I need some time. The lordships are pleased to grant me time on 4/7 to obtain instruction. But I have received a letter from him, lords, that some matter has been referred to some time, 1 week time. I will file that affidavit.
Requested on behalf of the contemners, list this matter on 1 week.
Item 42.
And to last order, my lord, I have served the copy of the contempt petition to the Learned Council for the opposite party who is appearing for the BSNL.
Which case?
42, my lord.
42.
And they have, as per his instruction, they have preferred SLP before the Honorable Apex Court.
So there is no contempt now.
So let me adjourn my lord for 4 years. It is not admitted also. Only
SLP has been filed or not?
they inform that they have filed.
Then if they have filed, then no contempt.
I pray the 3 weeks, 4 weeks adjourn maybe. The case may be adjourned.
It is based on the submissions advanced at the bar. It appears to be an admitted fact that this court's order dated 15/9/2023 passed in WPC number
15091 of 2019.
violation of which has been alleged in the present contempt application is under challenge before the Supreme Court by
On 16/7/2024, we have filed.
Supreme Court referred by
the by the department, my lord.
which department? State of Odisha
BSNL.
BSNL.
by the BSNL. So stop. In such view of the matter, in the court's opinion, the violation of the order cannot be said to be willful. So stop. The contempt proceeding is accordingly dropped.
Liberty may be given.
Liberty is always there.
Item
43.
My lord, item 43, this is an IA for modification of the order dated 25/6, my lords. My lords may come to page 3 of the IA.
No, which order you want?
25/6.
25/6.
Passed in the writ petition, my lord. Disposing of the writ petition. I have also annexed it to the IA, my lords.
No. What is the order?
There are some typographical errors and 2 clarifications, sir.
Clarification will not do typographical errors, yes.
On the amount, my lord, it's
The amounts are mentioned as 3,92,000. That has to
Where?
in para 2 and para 10, my lords.
Para 210. How much?
Para 10 million, both the paragraphs.
It is mentioned as 392,400. It should be 300,92,400.
300
92
92
400.
300,92,400.
My lords. In para 3, my lords.
Oh, that 00 is missing.
My lords.
In place of 3 crore, it's
3
become
crore
3
has
lakh.
become 3 lakhs.
Yes.
That is also related to the clarification, my lords. But para 3, my lords, this rule 29, it has to be rule 27.
In paragraph 3.
Para 3 of the order.
Last, the third line.
My lords, third line.
Yes.
And para 8, my lords, second line, the show cause notice issued on 16/3. It is mentioned as 6/3.
Para 8.
Para 8, my lords.
So 2 and 10, 27 paragraph. Instead of 29, in which paragraph 3?
Para 3, my lords.
This application has been filed.
My lords, also, the last paragraph, para 10, my lords may see, there is a specific direction to the petitioner to file to submit a fresh bank guarantee. However, there is no direction to the opposite parties to remit the bank guarantee with the order which has been passed. So that only if that is remitted back, I can file a fresh bank guarantee. Or else, my lords, in the alternate.
Hasn't that bank guarantee expired?
But no, bank guarantee was invoked and bank has paid this 3,92,400 to government.
Government
So
has already.
The order has been set aside by the lordships.
So that
unless he gets back the money,
He can't give a fresh.
that is what the pleading.
Otherwise, I'll have to give the second amount for the same amount. second guarantee of the same amount.
I am for the bank.
This interlocutory application, higher number so this application has been filed pointing out certain typographical errors in the order dated 25/6/2024, whereby the main application is whereby WPC number 120 was disposed of. Top. The seeking modification / clarification in the direction portion of the said order. Stop. We have heard learned counsel for the petitioner and learned counsel hearing on behalf of the bank. Stop. There appears to be no dispute that in paragraphs 2 and 10, rupees 392,400 has been typed in place of P00924000. Stop. The further in paragraph 3 of the said order, comma in the third line, section 29 has been typed in place of section 27 of rule, sorry. Rule has been typed in place of rule 27 of MCDR 2017. So stop. Thirdly, lastly, in paragraph 8 of the state order, comma 6 in the second line, 6/3/2020 has been typed in place of 16/3/2020. So stop. The state order stands corrected in terms of the present order and shall be read along with the present order. Oh, stop. Where is the direction?
Para 10, my lords.
Line 4, Mr. Acharya.
My lord, it has
Line-
been mentioned.
Mr. Acharya.
My lords.
In line 4, it is stated is amount is remitted to the Ministry of Mines, Odisha. Be that as it may, consequence of this order shall follow. That means if that order is set aside, that will naturally be returned, for
My
which
lord,
you have to
my lord
give up.
add a specific direction that may be refunded to me, because after that, immediately after that, it has been mentioned to the petitioner
Yes.
to furnish a fresh bank guarantee for
Because the
company.
bank guarantee which has
And
been
then-
encashed,
My lord, again, a 3-week period has been granted to me for the submission of the show cause reply, my lord.
So that can be done.
I'm for the bank, that is done, can be remitted back, and so that
Only this can be clarified, my lord, that the amount can be remitted back to me and I'll submit the fresh bank guarantee.
government has to remit it back.
We clarify that the consequence of washing off the order dated 31/3/2020 was cost.
My lords.
Yes.
Cost would also be that the amount in question is remitted to the petitioner for the petitioner to furnish a fresh bank guarantee.
My lords.
Is it clear now?
My lords, and this period of 3 weeks to file the show cause in that view, my lords,
Stop.
because it was from the date of order.
Since in view of the fact that the order has been corrected today, 3 weeks time as mentioned in paragraph, the time for the petitioner to file so-called reply is hereby extended by 3 weeks further from today. Will that serve?
My lords.
A small submission, Milord. The remittance has to be by opposite party 1, 2, and 4, Milord. That is to be.
One moment, Mr. Panigrai.
Milord.
Does it have to go to the petitioner or the bank can?
This will come to bank.
No.
Bank will.
If that amount comes to the bank, can you give a fresh bank guarantee?
If he requests for the fresh bank guarantee, will issue.
That amount can come back to the bank.
Exactly, that will be better.
Yes.
And I can request him for a fresh bank guarantee.
OP 1, 2, and
That will be faster also.
that will faster.
So, Mr. Mahanti, you see that the.
I get
No,
my lord.
my
I
lord.
will inform Union of India.
But then it is
Union of India,
written.
ma'am.
By
Then it
OP
is
1, 2,
Ministry
and
of
4,
Mines, India. Then
My lord,
that has to be corrected.
My lord.
Ministry of Mines, Odisha, that has to be.
The order was issued by the OP2 Regional Controller Mines India.
Ministry of Mines, Odisha is incorrect.
Yes. Ministry of Mines will be.
31/3/20 order was issued by the Regional Controller of Mines, which is OP2 here. Milord. So the OP2 may be directed
And
to
the-
remit the amount.
And my lords, the directions in the order forfeiting the bank guarantee was the FA may be realized and remitted to the government of Odisha. So what I understand is the bank guarantee has been encashed and remitted to the government of Odisha.
No means how do you know?
Because
If that is the order,
my lord.
if that is the order,
My lord.
then it has to come to you.
Not a Union of India because this is IBM.
Oh, but that is the order.
Normally it was paid to the Government of India, Minister of Mines, Indian Bureau of Mines.
Thereafter? Oh, in spite of the order, you given it to the government of India. But that is says it will come to the state of Orissa.
No, Lord, he didn't get the stay, so the government invoked the bank guarantee.
Government of India invoked the bank guarantee. IBM invoked
Government
the
of India invoked the bank
My
guarantee.
lord, not the government of Odisha.
It is not Ministry of Mines, Odisha. Ministry of Mines.
So who has exactly received it?
Indian Bureau of Mines, my lord.
OP 1, 2, and 4 may be directed.
So just a minute. So this also has to be corrected. Is remitted to the Ministry of Mines? Is remitted to the exactly to whom has it been remitted?
Indian Bureau of Mines.
Bank will tell us.
Bank have this.
The Government of India, Minister of Mines, Indian Bureau of Mines. Office of the Regional Controller of Mines, Bhubaneswar. That is
OP2.
OP2.
So this amount has been remitted to
OP2.
the
OP2.
Huh?
Opposite party 2 here in this petition.
In the further, in the 10th paragraph.
IBM has your office.
Ministry of Mines, Odisha shall be read as Ministry of Mines,
Regional Controller of Mines.
Regional Controller of Mines, Indian Bureau of Mines, Ministry of Mines, Government of India.
Regional Bureau of Mines.
Regional Controller of Mines, oblique, Indian Bureau of Mines, Ministry of Mines. OP2 is the address.
OP2, my lord.
Bracketed OP2.
OP2.
All right, we will see, my lord.
My lord.
Item 44.
Item 44, Lordship permitted to withdraw.
Item 46. Item 46.
Item 46, Your Lordship permitted to withdraw.
45 after 1 week.
Oh, then come.
After 1.